Hey everybody, how we doing? We are live. I just wanted to pop in here real quick. Let's do the intro and then we'll be right back and start it up. How does that sound? I just wanted to make sure I was here and fast, so we're on time. Let's do the mens rea.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Okay, there we are. Hi everybody. Welcome. It's that time of day again. It is Legal Vices time. Good morning, good afternoon, good evening. It is 10:03 p.m. here in sunny, not really sunny, more like dark and cold South Korea. So good to see so many of you here. The reason I wanted to just jump right into this was because I saw there's more than 100 of you waiting, and I didn't want to keep you waiting. I like that. I like when I pop in here, there's already 100 people waiting. There's 57 likes, and someone has already super chatted. So that's how awesome you guys are. What do we got here? We've got the Vault Dweller, Vault 7 Dweller, first, question mark. Yes, you're first. Haha, I'm here on time for once. I wish I could say the same for me. I was on time yesterday. That's all that matters. Alrighty, it is, when you haven't slept for about a week and a half, it's kind of hard to remember what day it is. I actually had to look at it's 10:30, it's 10:04 at night here, and I had to look at the calendar to see what day it was. That's how rattled I am. It is now Wednesday, the 16th. We've got a few things to discuss here before we jump into it. What are we doing today? First of all, let's talk about that. We're going to go back and we are going to watch the closing arguments from the Matthew Terry trial. Why are we watching the closing arguments twice? Because a couple of reasons. One, maybe some of you didn't see it yesterday, and two, I was really groggy by the time the defense got their time to give their closing arguments, and I want to see if they sound as stupid now that I'm completely awake as I was when I was very nearly completely asleep. Because they sounded pretty ridiculous and pretty bad and pretty damaging, as I recall in my sleep-deprived stupor yesterday. Yeah, Lorax was sleepy, but hey, we trooped out. And I wasn't sleepy enough to notice that you were all saying I was asleep in the chat. That's kind of, I was a good 80% asleep for the last 45 minutes, but I was awake enough to be aware of you saying I'm sleeping, so I wasn't totally asleep. I was just mostly asleep. Didn't have to go full on Snorlax, but we did good. And I'm kind of stalling a little bit for time here because, all right, I don't have to stall for time anymore, I don't think. Let me check the reason I was stalling for time was I was doing a YouTube download, not an external download, but a YouTube download of yesterday's proceedings to try to cut down a little bit on the buffering. We'll have to see if that works. Flux, they will sound even more stupid today. Great. So yeah, that's like that when you say stupid things when you're liquored up and then you go back and you realize they were even stupider than you thought. But speaking of being liquored up, I have this wonderful rosé port wine. It's kind of nice. All right. So that's what we're going to do. First of all, we're going to watch the the prosecution's closing statements. Then we're going to watch the defense's closing arguments. Then we're going to watch the rebuttal closing arguments from the prosecution. Then we'll watch the verdict. The verdict was pretty short, quick, and to the point. And I think court verdicts are the new spoiler alert. Because I said I would try to wake up for the what do you call that? The verdict, if I could, but there was no chance in hell of me waking up for that. Plus, I really did not expect it to happen. I really did not expect them to come back with a verdict that quick. It took them about an hour. So yeah, apparently there wasn't a lot for them to discuss. I've sent out an invite to Steve Gosney. Hopefully he'll join here at some point during our festivities. If not, we'll just fly solo on this. I think he'd like to see the arguments, and I'd certainly like to hear his comments on the arguments. So Steve, if you're watching, Check your mail for links. And then nothing's going to happen. We'll do this. It'll take about 2 hours to get through this, I think. And then at noon Central Time, which is 1 p.m. Eastern Time, and that is 3 a.m. my time, will be the Brooks actual real sentencing. I don't know if Nick is streaming that or not. Those of you that know in the chat, because I literally was just working my ass off in the office today and couldn't watch Nick stream. Is Nick streaming the Brooks sentencing today? I hopefully okay, he's streaming it, good. So if he sends me the link, then I'll be on there. If not, I'll just be sleeping peacefully. And I guess so. What's going to happen now? Well, we'll talk about that later. We'll give the weekend preview later at the end. We don't need to talk about that now. All we need to talk about right now before we jump into these closing arguments is hit that like button. I know it's the daily hit that like button beginning intro semi-griftathon. I don't grift for the super chats. I grift for the likes. 300 of you here, less than 50% have done your job. 130 likes, 132 likes now. Don't make me go full Andrew Branca and threaten to shut down this stream on your asses if I don't get at least 50% likes. You guys are always great. I always get like way more likes than most people get because you like me more than most people, I guess. The ratio is great. So do me a quick favor. See, look at that. I just had to even mention likes and boom, we're way up over 50% already. 303 people here, 172 likes. Get down there, hit that like button. We should have 300 likes right now. And if you want the super chat rule, if you're not familiar with the super chat rule, there is no super chat rule. There is no minimum requirement to participate. There's super chats aren't required for interaction. I try to do what I can with the chat, but it's difficult to keep on top of everything while the chat's going and I'm paying attention to the video. I'm trying to think of things to say and talk about. We've got guests to entertain, things like that. So it's kind of hard to keep track of everything going on in chat. I do my best. But the super chat, you're throwing your hard-earned money at me, so that guarantees that I will read your super chat and I will respond to it, and we'll have a little bit of discussion about it. During the trial, however, I'll flash it up on the screen, and then when there's a lull in the proceedings, I'll read them and address them then. Unless it's a $100 super chat, which immediately gets immediate recognition and the accompanying $100 super chat shot. All right. That's how we'll proceed. So hit the like button, hit the subscribe button, by the way. I tried to get up to 32,300 subscribers yesterday. We got up to 3,299. Let's see where we're at right now. Right now we are at exactly 32,300. So, hey, in a perfect world, I'd get 100 subscriptions out of today. Probably not thinking about that. Probably never going to happen. But if you haven't hit that subscribe, make sure you do. And if you have subscribed, make sure you're still subscribed because you two are kind of dicks anyway, but YouTube are also dicks. They randomly unsubscribe people. And speaking of events in the world of law, we have some LawTube drama to report. I don't do drama streams, but this is for a good cause. Good Logic, Joe at Good Logic. He was shut down midstream. He was given a copyright strike midstream earlier when he was reviewing. Joe, being the good Jew that he is, was reviewing Dave Chappelle's comedy bit on Saturday Night Live, breaking down whether it was anti-Semitic or not. And right in the middle of that, he got blasted. So YouTube blasted a Jew for reviewing a comedy bit to determine what parts, if any, were anti-Semitic. So if you have the inclination, please pop on over to Twitter, because weirdly, using Twitter is the best way to get to YouTube. Go figure. Tag at YouTube creators, and at Team YouTube. Those three are the main ones that get things done on Twitter for YouTube, weirdly. Tell them you think it sucks what happened to Joe, and free Uncle Joe, get Joe's YouTube channel put back up and have that strike removed. Yeah, it kind of almost does sound like YouTube being a little anti-Semitic, doesn't it? So that's the LawTube drama for the day. Joe forgot. Funny man is bad. Yeah. So, all right, it's not much drama, but hey, it's drama if you're Joe. And we will be diving right into, but first, this is as I said, my channel is Legal Vices because we do legal stuff and we talk about vices. I have pretty much three main vices in life: alcohol, cigars and pipes, and watches and clocks. Today, just before we get going, this is just kind of a weird little thing I just wanted to share with you that I got today. Quite proud of it. It's my latest timepiece acquisition. It's this baby right here. I don't know how well you can see that, but this is my latest timepiece acquisition that I got today. This clock. This is quite an amazing clock, and it's loud AF. You can hear it. I can hear it literally across the house. What this is an actual clock for a Russian MiG fighter jet that was manufactured in 1984. It was never been in a fighter plane. It's a spare part, basically. This is a replacement clock built in 1984 for a Soviet MiG, a Soviet MiG fighter, not even a Russian MiG. It was a Soviet MiG fighter jet that this was built for. This is like really, really cool, and I'm kind of happy with that. That's why I was 2 minutes late. I had my Russian friend over here, and he was delivering me the Soviet MiG fighter pilot clock. And Xcomer Triple Z with another super chat says, imagine all the clocks you would get if that post box was up. God damn it. I swear I'm going to the post office tomorrow. I had no food in my house. None. Like literally I had no food in my house, so I had to go to Costco at lunch today. I'm going to the post office tomorrow. So that's what we're going to get up. I'm going to the post office tomorrow. But there we go. Anyway, for any of you that likes clocks or timepieces, that is the clock out of a Russian, well, not out of, it's a spare part for a Russian Soviet MiG fighter jet. You got like the main clock, and this part here, that is like a flight time calculator. So when you start your flight, you hit the red button, it starts that timer. And there's also, you hit this button here and it starts a stopwatch. So you can do a timer there. That, you know, that's kind of it. But this is loud. All right, that's it. That's enough of my weird stuff. That's show and tell for today. Show and tell is over. Did it come with a MiG? No, that would be really cool. So all right, that's it. I was kind of trying to buy a little bit of time to see if Steve would show up. Steve hasn't shown up yet, so let's jump right into this. Again, we are watching the closing arguments in the Terry, let's call him Terry Brooks. He's an author. Sort of Shannara, for those of you that know. For Matthew Terry's trial, defense goes second, then we have the rebuttal. So prosecution, defense, prosecution, and then we'll skip all the jury instructions, skip the deliberation time, and go straight into the verdict, and then we'll talk about what we're going to be doing next on this channel of mine. Let's bring up the stream and see how long it takes before we start buffering. And boom, here we go. Are we ready for this? Sped up, please. No, we want this real time. If we speed it up, Stingy, then that just means I go away that much faster. And I know you want to spend your morning, afternoon, evening with me, Legal Vices, on the Legal Vices channel. Hit the like, hit the subscribe, and let's dive in. All right, speed it. Here comes the jury. His life is on the line officially now. It's all up in the hands of the jury. And now don't post what happens here in chat. No spoilers in chat. Because I was expecting to, if I didn't know what the verdict was, I was going to come back tonight and learn the verdict as we reviewed it. But I literally woke up to about 50 emails and text messages and Twitter DMs telling me what the result of the trial was. And Flux, hey, I can super chat. Woo! Also, I talked in my video about it. Alrighty, go to Flux's channel, subscribe to her. Oh yeah, the judge met some of the jurors in the restaurant where he was having lunch. And we're definitely going to need to bump up the volume. All right, we're up 400%. Let me know if I need to increase the volume of the court video at all, and we'll go with it. And again, no spoilers on the outcome.
As you may recall from the opening,
this is not live. This happened yesterday.
Attorneys have rested their cases. They have the opportunity to present.
But we're pretending it's live.
I have one very brief instruction that I intend to read you before their closing arguments. Then after their closing arguments are completed, I have the more substantive instructions regarding the law that applies to the case. I
Okay,
also
yeah,
want to let
the,
you know that this copy of the instructions will go back into the jury room with you.
The layover that was made for the law and
So I'm gonna
cuck
give you
overlay,
the first
I can't
instruction
use that. That is
before you
way
give
too
the
graphic.
Both the state and
It's
the
law and
defendant
cuck,
have
and
now
it's all
listed their
white
case.
and sticky
The
and
attorneys
drippy. I
now
can't
will
use
have-
that.
will present their final arguments. Please remember, that
Stingy,
what the
but you
attorneys
can
say
watch the
is
Brooks
not
DA yell at him
evidence
after. We'll do
or
that.
Your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Diaz is the state.
Okay. I didn't know that they had time allocated for their closing arguments. Yeah, no, this is like
In the
live
not-too-distant
drippy.
future,
It's pretty graphic.
You will retire to the jury room and you will have a chance to start your deliberations. I want to use this opportunity to talk to you about some of the things that you're going to be read by His Honor. He held up the packet of instructions that he's going to give you. We've had a chance to see those in advance, and so I'm going to talk with you about them. But obviously, the words that actually come out of the judge's mouth and the packet he actually gives you, that's the law. So this is the verdict form, and this is the way by which you ultimately tell us what your decision is. And so you may have come into this trial, although I think I addressed it on jury selection, if you remember back 2 weeks ago, thinking that it was either guilty or not guilty, and that's not exactly correct. So on the verdict form, you're going to see 4 choices. There's first-degree murder, that's choice number A. You're going to see second-degree murder, that's choice number B. You're going to see manslaughter, that's choice C, and then you'll see not guilty as choice D. These are arranged in a particular order for a reason. The highest level of offense is listed at the top, first-degree murder, then second, then manslaughter, and then obviously not guilty. As we discussed during jury selection, you may remember my cheeseburger analogy or my hamburger analogy, and this is where that all comes into play, okay? Manslaughter is the hamburger. Second-degree murder is cheeseburger. It's everything.
Yes, we
hamburger
watched
is,
this
but it's got
yesterday. We're
a little bit
watching it
extra.
again
And
today
then
because I
bacon
want to
double
watch it
cheeseburger
fully
is
alert.
First-degree murder. It's everything cheeseburger is, but it's got something extra. And so as you go back, you will be asked to decide which of these 4 options is the correct answer. And I submit to you that having heard all the evidence, including the testimony and the exhibits that you will have a chance to take back and look at for yourself, including the videos that you can watch again, you will apply the law and you will see that the only just verdict is.
All right, we're going to go through this again. For those of you that missed it a minute ago. Yes, this is a rewatch. We are rewatching the prosecution's closing arguments, the defense's closing arguments, and the prosecution's rebuttal. And we're going to watch the verdict. Yes, we're rewatching the closing arguments for 2 reasons. Some of the people that are here now didn't see it yesterday, and we want to watch that with them. The other reason was I was really, really, really tired out of my damn mind by the time this was going on. And I remember about 50% of it, and I want to see if it was as ridiculous as I remember it being, to which Flux has said it's probably going to be more ridiculous than I remember it being. So we're going to watch this. We're going to watch it with some fresh eyes. We're going to have new comments because I don't remember anything. And then we're going to watch the verdict, and we'll wrap it up with that. And then we'll talk about what's happening in the rest of the week. So that's why we're rewatching it. And of course, the fat, bald prosecutor, who vaguely resembles fat, bald me, is talking about cheeseburgers in his closing arguments.
First-degree murder. Now, if you're looking carefully at this, you may see that there's also this other part about something here you have to check. During the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use, or he did not carry, display, so on and so forth. And we're going to talk about that too, because that's something that you haven't heard about. You'll get an instruction that applies for that as well. But it's very simple. You will go back, and when you reach your verdict, you will check either A, B, C, or D, as it says. And if there's one of these things that's an or, you're going to check either one or the other. That's it. That's how you ultimately tell us your verdict.
That's how you ultimately
So, I wanna
determine
talk
if
to you
someone's going
about
to
some of
die
the
or not.
Rules that you'll get in a variety of places to help you understand the job that you're supposed to do before we even get to the question of, did the state meet its burden, which I submit to you we did. You will get an instruction, which will actually be one of the last instructions the judge reads you, and it's called submitting the case to the jury. It's 3.13. You don't have to write it down because, again, you'll get it. But the first thing is, there are no other laws that apply to this case. The judge has had the chance to review the facts and to address the law, and the packet has been created, and whatever laws apply, that's what's been given to you. So if at any point you find yourself back there thinking, well, like, is there some other law that plays in here? What about this thing that I think might be the law? Remember, we talked about this. Your job is to apply the law as it is, not as you think it should be, or it could be, or it would be. The judge is giving you all of the instructions. The next one is the verdict form. Let me zoom that out just a little bit.
He's not hairy enough to be a bear.
Okay. The state of Florida carries the burden. The government carries the burden. All right? The burden is beyond and to the exclusion of all reasonable doubt. But there's a trade-off for that. If the state of Florida proves to you that the defendant is guilty, you should, not could, not might, not may, you should return a guilty verdict if we have convinced you for the highest offense that has been proven beyond a reasonable doubt. And I return to what I talked about in jury selection. When the state of Florida has convinced you of first-degree murder, I have inherently convinced you of second-degree murder and manslaughter. That's the only way that can work. So I would certainly convince you of the lessers, but you find him guilty of the highest, which again is ranked very easily on the verdict form. It starts at the top. We prove first-degree murder, you find him guilty of first-degree murder. You will receive rules for deliberations, and I'll talk about some of these other ones, but I want to talk about this one first, number 5. Whatever verdict you render must be unanimous, which means that each juror must agree to the same verdict. That means that when the time comes to check the box on the verdict form, you have to all agree to check that spot, okay? But why you check it doesn't necessarily have to be unanimous. There is a question that you will ultimately have to answer for yourself. Did the state of Florida prove premeditation? And where and when did premeditation start? And that may be slightly different for all of you, and I will talk about that in a moment. But one of you may think it starts a little bit earlier or a little bit later. The only question is ultimately, do you think the state of Florida has convinced you the defendant had sufficient time to reflect before he committed the crime? And whether you think he had 3 seconds, 30 seconds, or 3 minutes, the state has convinced you. So you only have to be convinced, and you have to agree on the final decision, but you may have slight disagreements. You know, you may think there's 7 wounds, there's 8 wounds. You may think that there's this wound is defensive and that wound isn't defensive. You can have these disagreements. The question is, when it comes time to check the box, are you unanimous? And if you're convinced and everybody else is convinced,
Hey,
you
I'm
are
muted. Isn't that
unanimous under the
cool?
law.
I know I'm muted now. I muted it when I
next is this
coughed
one.
and I forgot to put it back up. I was just saying, no
We
spoilers.
talked about this. Whether the state has met the burden of proof does not depend upon the number of witnesses it has called, nor upon the number of exhibits it has offered. Now, I think in total you've heard about 31 people in this trial, and there's somewhere in the neighborhood of almost 70 pieces of evidence, not counting each individual photo that is, then clustered inside.
Yes, Florida is in the
That's
courtroom.
not the
Wisconsin
issue.
never
The issue
showed up.
is the nature and the quality of the evidence presented. That is the issue. And I submit to you that on the nature and quality of the evidence that has been presented, the state of Florida has proven that this case did occur, that the defendant is the one who caused the death, and that he did so with a premeditated intent. The state of Florida has met its burden.
Do you
And
think
so-
he's really nervous, or do you think he knows he's going down?
You may say to yourself, well, there's no eyewitness. And that's true. There's no living person standing there to say what they saw. But there is no requirement that there must be an eyewitness. You may say there is no video of the event. There is no audio recording of the event. And those things are true. There is no getting around that. But that is not the requirement. As I discussed with you, there is no formula for guilty. The state of Florida must convince you, and I submit to you the state of Florida has convinced you. It's a question of the nature and the quality, not the number. So I want to draw your attention first to 7.1, which is the introduction to homicide. And again, you're going to see some basic things that we've already talked about. The defendant's accused of first-degree murder. It includes the lesser crimes of second-degree murder and manslaughter. They're all unlawful. If you find that Kay Baker was killed by Matthew Terry, you then consider the circumstances to decide whether it's first.
Just a little
second, or
post up here,
manslaughter.
whether you watched this
Again, these
yesterday
are
or
all
not.
things that we've covered, but we're going to come back to this instruction
A little poll going on here.
in a moment. So let's talk about what is murder in the state
I was
of
about
Florida.
80% asleep. I was awake,
First-degree
but not.
murder has three elements. Very much like I suggested, there is, top bun, the middle piece of meat, bottom bun, sort of like hamburger, although obviously this has got more bells and whistles than manslaughter. There's three elements. The first one is Kay Baker's.
It has
You know
more
that to be
bells
true.
and whistles
State of
than
Florida entered
manslaughter.
a stipulation that is in evidence. You will be able to take that back. The state of Florida and the defense have agreed that Kay Baker is dead. That element is met. There is no doubt there.
Yeah, there's no doubt.
Then
she's
there
dead.
are two more elements. The death was caused
Oh,
by the criminal
hang on.
act of Matthew Terry. That's the question of identity. And there was a premeditated killing of Kay Baker. That was the intent element. And what you will see is the difference between all of the offenses is the question of intent. The intent gets a higher level as you move up. But I want to stress this because we talked about this. Killing with premeditation is killing after consciously deciding to do so. The decision must be present at the time of the killing, meaning you have to have decided beforehand. You can't decide afterwards. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period must be long enough to allow reflection. And I submit to you that in this case, premeditation starts well before the killing does.
Now he's saying that you have to premeditate. You have to have a
Starts
period of
before the first
reflection
knife
between the
moves
time the
to the
idea starts in your head and you act.
Premeditation
That can
lingers
be
and continues
half a second.
on
It could be a
every
millisecond.
step of this murder. Every time the defendant makes the choice to again plunge the knife into the body of a woman, to slice her open, to
Ugh.
cut her throat, to cause her to bleed to death, every single one of those is an intentional act where the defendant is again
Wait, what?
making a choice.
Your son was
Stab
one of the
her
original
once,
jurors and
enough,
was
let me
excused?
stab her again. That still didn't get her.
Like
Let me
just
stab her again.
before they selected the
Kay
jury,
Baker
or
suffered
after they selected the jury, he was one of the
multiple
two
wounds
that
on the way
was
to the one
let
that
go.
ultimately claimed her life. And each of those is an act of premeditation. But again, I submit to you that premeditation starts long before that. And we will talk about that in a moment. So, as part of the instructions, as I told you, you will also get an instruction about the use of a weapon. That thing where you have to check the either or option about did carry, use, threaten to use. That's this instruction. And you'll see this instruction repeated for each of the offenses, which is why on the verdict form, each of the offenses has that option to choose beneath it. This is just one I'm using for example. It's the one for first-degree murder. You'll see that the state of Florida has to prove to you the defendant did carry, display, use, threaten to use, or attempt to use a weapon. And if we did, you should find him guilty of first-degree murder with a weapon. So you check A for first-degree murder, and then you check did carry, use, threaten to use, display, or attempt to use. And that shows that it's with a weapon. That's what this instruction is about. You'll see that a weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design. I submit to you the weapon here is a knife. And you might think that a knife is typically used for in a kitchen to chop vegetables or maybe to chop up some chicken or whatever the case may be. But it's also any object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. So even if the knife in this case,
Yeah, I
the
think
knife
we'll.
would normally sit in a kitchen.
I think we can pretty much safely say a knife is a weapon.
The minute it's picked up and used as a weapon to inflict murder, it's a weapon. It's a weapon at least under the second option there. So I want to talk with you about a variety of things that you're going to see in the instructions, ways by which murder may not be murder, meaning a killing may not be unlawful. One of the ones you'll see is here. This is again in the introduction to homicide. You'll see the discussion of justifiable homicide. A killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant. That is a form of self-defense. right? Someone is trying to kill a person, that person can defend themselves. Matthew Terry was not resisting anyone's attempt to murder or commit a felony upon him when he killed Kay Baker, because Kay Baker was not committing a felony or trying to kill him. There's also the intent to commit a felony in any dwelling house in which the defendant was at the time of the killing. And I submit to you that yes, this case certainly started in a home, a dwelling house, but that's not where it ended. And so that section does not apply. There is nothing under the law that is given to you that says that this killing is justifiable. It's not self-defense, and so it cannot be excused for some justification. You'll also see this instruction for excusable homicide, right? And what you're going to see over and over are the words accident and misfortune. The killing of a human being is excusable under any one of the following three circumstances. Whether the killing is committed by accident and misfortune, which is not what happened here, in doing any unlawful act by lawful means with the usual ordinary caution and without any unlawful intent. So you don't even have to struggle with the usual ordinary caution and without any unlawful intent, because what happened to Kay Baker is not an accident. It is not a misfortune. It is an intentional killing. Whether the killing occurs by accident or misfortune in the heat of passion, upon any sudden and sufficient improvocation. And we're going to get to heat of passion again in a second. But again, it's not by accident. It's
That
not
would
by
be a
misfortune.
bonus.
It's not excusable. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Well, first off, there is a dangerous weapon used. That's clear. The knife killed Kay Baker. That's a dangerous weapon. But even still, again, accident and misfortune immediately disqualifies this from excusable homicide. And so it's not justifiable. It's not excusable. You may look to the actual instruction for murder again, right? We saw the top part, and as you move towards the bottom, you'll see here, an issue in this case is whether Matthew Terry did not act with premeditated design to kill because he acted in the heat of passion based upon adequate provocation. In order to find the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, and I wanted to point out to you that A, B, C, and D all end in the words and, because it's got to be all of them. It's got to be all of those things to be excusable under the heat of passion theory, okay? So there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused the death, and Matthew Terry was in fact so provoked and did not cool off before he committed the act that caused the death of Kay Baker. And I submit to you, that does not apply. Whatever argument took place between Matthew Terry and Kay Baker on that night, what Matthew Terry did to Kay Baker was not.
All righty. Well, we tried to outlaw and cuck, so let's go back to potato vision. That's how we roll. Back to
What
tater
a
vision.
reasonable person does. It is not how a reasonable person reacts. This is not a situation where a man comes home and finds his wife in bed with another man and his whole world disintegrates in a moment. Maybe that would apply then. But that's not what happened here. What you have is an argument that started at 10 o'clock.
Legendary
and
Jason
carried all the way
Gilliam
until
Jr. is a new member
slowly escalating. Multiple
of the
chances
clean and
for the
sober
defendant
level.
to cool off. Multiple
Well,
chances for
we got through a few minutes
reasonable
before we started
person
buffering.
to cool off.
4.5 minutes, great.
Nothing about what happened here is the actions of a reasonable person, and I submit to you that the heat of the moment, based on adequate provocation, does not apply. As we discussed before, you'll hear this. You probably, I think, heard me read these words directly. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. That does not say it is not a defense to first-degree murder, or it could be a defense to second or manslaughter. It's not a defense to any crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that he lacked the specific intent to commit any crime. Matthew Terry was intoxicated that evening.
Yes, he was.
You can watch the video. You'll see him drinking. You've heard the testimony of the people who were there, who will tell you that he had clearly been drinking and he was clearly under
Yes,
the
he
effects
did.
of alcohol. And you will see the medical records, which will tell you that after he stopped drinking somewhere at 11:30 and is found somewhere about 5 o'clock in the morning, almost 6 hours later, he's still a .072 because he's had 5 hours to sober up.
Yeah, a guy that
Voluntary
blows a
intoxication is not
.7
an
something
offense.
5 hours after he stopped drinking
So I
was
submit
drunk
to you the question
AF.
is, did the defendant commit this murder, and did he have the requisite intent? I return back to the instructions on murder. And I submit to you that he did. Was the defendant the one who caused the death of Kay Baker? He's the last person with her at the landing. He's the person with her in the car. He's the person with her that gets home. You can see their shoes kicked at the front door. You can see Miss Baker's phone sitting on the kitchen counter. You can see the defendant's phone and the keys to his car sitting on the nightstand in the bedroom. You can see the shorts he was literally wearing when he was at the landing that he's not wearing when he gets arrested, and they're sitting right by the door where he kicked it off. And if you look carefully and go look at the photos, you'll actually even see that Kay Baker got home and changed shirts. In the video, she's wearing a red t-shirt. When she's found, she's got a sort of purple camisole on. And if you don't think she got home, I will submit to you that go look at the photos from inside the house, and the thing that you'll see that hasn't really been discussed is the same thing that every woman knows. After you've been at work all day, after you've been out partying, first thing you get home, the first thing you want to do is you take your bra off, go look at the picture, and you'll see her bra tossed right on top of the hamper when she got home.
Is that true, ladies? Is the first thing you do, you whip off the titty holder?
There's no forced entry into this home.
I whip off my
They are
pants.
the
So is that the
last
same
two people
thing?
Together, 30 minutes before Kay Baker is dead. And the defense may suggest to you that somebody broke into this home and point to the window that is the screen pushed out. But that's why I took the pain to show you that the stuffed animal
That's
sitting
a
on the
resounding
floor
yes from the
comes
ladies.
from inside the
Absolutely.
bedroom. It's not out of the house because somebody is climbing out of the window. The stuffed animals that are by the window are not pushed into the room. They're still sitting on the bed where they belong in a kid's bedroom. They're pushed out because somebody went out the window. So Kay Baker and Matthew Terry are alone in a house with no sign of forced entry. There's clearly some argument that happens in the house that leads to not only the master bedroom door, but the kid's bathroom door both being damaged. I submit to you, Kay Baker is the person who goes out that window. She's a small framed female. She runs into her kid's bedroom, she locks her door, she opens a window and she crawls out a window. Because she's trying to get away from the person that's attacking her, the only person that's in that house, that man.
Good statement.
That's why the front door is open. Because the defendant comes out the front door and chases her down. That's why Kay Baker isn't killed in the bedroom. That's why she isn't killed right outside the window. The defendant is taking the time to run around the house to try to intercept her.
The verdict will come immediately after closing arguments.
He's the last person seen with her, and when the time comes and he's found, he's literally caught red-handed. Red-handed because he's got Kay Baker's blood on his hands. The same hand that ran from Kay Baker, ran along the fence line, got to the edge of the fence, and first started to think about climbing into the bushes, and put his hand on the fence to brace himself. That's Matthew Terry and Kay Baker. That's his hand on the fence.
Hey, Ellen.
And you might say, well, if he's right there and he's going to climb through the bushes, why doesn't he do it? Because if you look at the path, what happens next is Jonathan Figgins comes outside. He hears a voice, and not long afterwards, the lights are turned on in the backyard of Jonathan Figgins' home, and the defendant is standing at the edge of the fence line. So now he runs away from Jonathan Figgins, he runs away from the light in the backyard of the Figgins home, and he runs diagonal across 6209 to 6207, and then he crosses the bushes. The defendant is the person who committed this crime. He is the one who caused the death of Kay Baker. And so Did he do it with a premeditated intent? I submit to you, yes. Now, I need to be clear. What you will not see in the instructions is the word motive. Why he did it is different than did he think about it.
Uh-huh.
And we have presented to you the motive. Matthew Terry was upset at his girlfriend for what he thought was an act of infidelity, dancing with another man. He was so upset about it, he had to argue about it with her friend, then with her and her friend, and then he had to make another phone call on the way home because an hour and a half later he still hadn't let it go. Now, was he intending to kill Kay Baker at that moment? That seems unlikely. But they get home, and now the couple's having an argument. And again, maybe she tells him, I don't love you, I've had enough of you, this is over, get out. Or maybe she just tells him, you know what, you're being an idiot, sleep on the couch. But something upsets Matthew Terry. Something upsets him enough that he realizes he is no longer in control. He cannot control Kay Baker. Because watch that video when Kay Baker goes to the bathroom. You will watch him watch her. And he immediately goes in right after her. And when she comes out and she's dancing with her friend, and he thinks she's dancing with another man, he walks past them, and the first thing he does is he turns and looks back at them. But keep watching the video. Watch Matthew Terry go outside onto the patio and watch him get back up from the table, walk all the way to the door inside the bar, and he peeks in because he's checking on Kay Baker. Because he thinks that he needs to supervise her. He needs to control her. And I submit to you that whatever happened in that home, whether it was an argument about dancing, or it was the threat of the relationship ending, or he just felt disrespected because she told him to sleep on the couch, that's where it started. That's where doors start getting closed. That's where the master bedroom door gets closed. That's where the master bedroom door gets broken. And Kay Baker gets out of that master bedroom and finds her way to the kids' bathroom and to the other bedroom, and she pulls doors closed, and the defendant comes kicking in doors, and Kay Baker is frantically scrambling out of a window.
Oh, don't do this. Thank you.
So the defendant chases after her. And that is where intent starts. Because let's be really clear, some weapon killed Kay Baker, and I submit to you it's the paring knife that comes from the butcher block sitting on the counter where it's the only knife in the house unaccounted for. And if you agree that that's the knife that killed Kay Baker, then someone had to bring it outside the home. And that's the man who brought it. When he grabs a knife, when he chases a woman down who's fleeing, when he's been chasing her in the home, when he's kicking in the doors, the premeditation is already forming. And every step that he gets closer to her as he chases her down, the premeditation is only growing. Kay Baker suffered a wound to the back of her neck. A wound that Anna Cox told you had to be higher than the shirt that she's dripping down onto. Jonathan Figgins told you he heard a thud, like somebody hitting the ground.
Ground.
And Anna Cox told you that Kay Baker's throat is open right next to Jonathan Figgins' wall, and very shortly thereafter, and very briefly, she's moved to the place where she died. The place that she never moved from again. Kay Baker got slashed in the back of the neck because someone was chasing her from behind. She was running. She gets hit in the back of the neck, and in the struggle, she gets knocked to the ground. And someone is on top of her. She is either laying on her back, or she is basically laying face down on the ground, and somebody is going to open her artery. And it's going to spray on that wall that you saw. That is intent. And it's that man's intent. It was that man's intent to kill Kay Baker that night.
I like his passion a lot.
It was his intent with every single time he stabbed her, he slashed her, he cut her. That is the only reasonable conclusion.
Oh, did Tank Rat do some
Was
Santa
Matthew Terry angry?
stuff?
Yeah, I'm sure he was. Does that mean he didn't commit first-degree murder? No. He was not acting in the heat of passion as a reasonable person. He was acting as a boyfriend who wanted to put a woman under his thumb. Who
Under
wanted
the
to
ground.
show her that he was in charge. That's who Matthew Terry was. In a moment, I will sit down. Before I do, I just want to talk with you about this. Whenever the phrase a reasonable doubt is used, you must consider the following. And I'm only going to read a portion of it. That's not because I'm trying to hide the rest of it. You're going to be given this in black and white. You can read it for yourself.
And the judge will read it
But
to
a
you.
reasonable doubt is not a mere possible, speculative, imaginary, or forced doubt. It is easy. It is too easy to fall into what is possible.
Hey, we got a Meme Copium raid. Welcome, Meme Copium and
To
crew.
imagine
Good to have you here.
about what the real story could have been. To force
Make sure you hit
yourself
that like
to believe
button.
Something that defies common sense. That is not reasonable doubt. There was no other person that attacked Kay Baker that night. The defendant did not rush to her aid and get his blood on his hands because he
Oh, come on.
was trying to help his girlfriend. He did not either get chased by the phantom attacker nor chase down the phantom attacker as if it's some narrative that he's the brave hero. Matthew Terry killed Kay Baker. He ran from the scene. He ran through bushes. He ran a football field down the road. And what he did was he opened his own neck.
Yikes. Wow.
He opened his own neck. And then he laid in the darkness.
Come on, don't do this. Don't do this, Lon Cuck. We are on potato cam vision, and you're still doing this. Come on. All right, well, we're catching up on the buffering here. Everybody reach down and hit that like button, because who doesn't like buffering? Yeah, we're buffering, so hit that like button.
In the bushes for 5 hours until he was found. Do not fall into the rabbit hole of what is possible, imaginary, speculative, or what you have to force yourself to believe. Use your common sense. Look at what is reasonable from the facts. And when you do, it is clear the state of Florida has shown you what has happened. And if you find yourself thinking, I just wish there was someone who had seen what happened that night who could tell me for real, it's Kay Baker. Kay Baker can't say it because Kay Baker is dead, and she's dead because that man killed her. Find the defendant guilty as charged. Thank you.
Okay, that was the prosecution's cue to stand up and deliver what I remember to be a really bizarre closing argument. Started out, I thought, very, very well. And in my nearly sleep-induced stupor, I just remember it being like, what the hell? And now that this is one of the reasons, like I said, why we're rewatching this. I want to see if it's as bad as I remember it being. I think the answer to that's probably going to be yes. So before we get to the prosecution's closing arguments, let's talk a little bit about the defense's closing arguments that we just watched. Now with that, the prosecution has the entire burden of proving everything. Yeah, the Chewbacca defense, that seemed to come literally into play. The prosecution has to prove everything. The prosecution has to prove beyond a reasonable doubt. And as he said, that doesn't mean any, nonsensical, ridiculous theory you can think up. A common sense, reasonable doubt that he did this. You have to prove beyond a common sense based reasonable doubt that he did this. What have they shown so far to tie him to this? No, the prosecution has to show everything. The defense has to show nothing. The prosecution has to prove beyond a reasonable doubt that he committed the murder. The prosecution has the entire burden of proving everything. The defense they have to do nothing. They don't have to do anything. They can just stand up and say they didn't prove beyond a reasonable doubt. The end. The prosecution has the burden. The defense doesn't have to explain what he was doing at the time. The defense doesn't have to explain what really happened. The defense doesn't have to offer a theory of what happened. The defense doesn't have to say a damn word. The prosecution has the burden of proving. They have to show where he was, what he was doing, and that he was the one responsible for this. Yes, that was the prosecutor that just went. So that's what the prosecutor did. The prosecution, they have the burden of proving everything. And what did they just do? Did they prove, through their arguments, based on the evidence presented during trial, beyond a reasonable doubt that he was responsible for this? I mean, the murder weapon was never found, but circumstantially, there is a very, very heavy amount of evidence against the accused. The door was locked from the inside. The bedroom door was locked from the inside. Someone escaped from that room. Nobody went from the outside in and through the locked door, because you remember the police had to kick the door in. So for some reason, somebody was inside of a locked room and they went out the window. His blood, I think, is the most damning evidence. I mean, there's lots and lots of these little circumstantial things. She's alone in the room. He's the only one in the house. He didn't go out the window. But I think the more damning evidence is the blood. Her blood is all over everything. And his blood is mixed with her blood on the fence, and his blood also trails off to the bushes where they found him. I mean, intellectually, Edward M. Lockwood is saying, yes, he did, it's obvious. Intellectually, yes. But legally, is it proven? Is it proven beyond a reasonable doubt that the guy sitting in the defense chair is the murderer? I think so. I think I was concerned until the blood evidence came in, where it was found, where the mixed parts were found, and the running the DNA analysis. That's when I thought, okay, fine. The prosecution has proven beyond a reasonable doubt, but the defense, I don't know if I would. Well, yes, I do. I know I wouldn't have done what she did. Let's burn through a couple super chats here, then we'll dive right back into it. Flux says, all she did was destroy any doubt the jury had with her performance. My performance wasn't as good as the defense. I would have felt insulted. That's how I remember it. Jillian N., bras are prison. Thank you so much for the super chat. Yes, they are. And Rebecca Glasgow asks, do you think the prosecution didn't get all the evidence tested because of time constraints? 6 months is not a lot of time. Well, that was their excuse. That's what they were saying. They said that you're only allowed locally by local rules to send in 5 pieces of unknown evidence at a time. Apparently you can send in unlimited amounts of known evidence, but if you're saying, hey, we have this, we need to know what this is. We need to know whose DNA is on this. You're limited to 5 at a time. But Steve Gosney, the public defender from Florida, who's been on here the past few days, has said that if it's a capital murder case like this and the defendant has not waived his right to a speedy trial, they will allow you to have whatever you need tested. So it's a little bit of both. It's a little bit of they apparently didn't take advantage of what they could have to have the evidence tested, but also they were at least under some modicum of constraint in the number of things they could send. Well, at least that could have been overcome. So that's the long answer to a short question. All righty. Let's jump back into this. This is now the prosecution's time to sit back and watch. Like I said, the judge said they have equal time. The prosecution has equal time as the defense. But the prosecution has the possibility of dividing their time. Say they both have 20 minutes. Prosecution has 20 minutes, defense has 20 minutes. The defense only gets to speak once. The prosecution can allot part of the time to their main closing argument and reserve a smaller, or reserve however much time they need for a rebuttal argument after the defense has spoken. And that's what they've done. So say, like they have 20 minutes each. The prosecution says, okay, I'll use 15 minutes for my main closing argument. The prosecution the defense uses their 20. Then the prosecution comes back and says, okay, I'm going to use my last 5 minutes for a rebuttal closing argument. That's what they did. So we're going to hear from the defense, and then we're going to hear from the prosecution. And what I'm going to do is, because of all of this lovely buffering stuff that's going on, I am going to, I did a YouTube download, not an external download of the video because I didn't have time, but we'll watch the YouTube download that I have. And hopefully that will solve some of Law and Goofball's buffering issues. Hopefully.
The state has convinced you. So you only have to be convinced, and you have to agree on the final decision, but you may have slight disagreements. You may
I'm
think
fast forwarding here to where
provocation, and we're going to get to here.
Fast forwarding.
Edge of the fence line.
Fast forwarding. Alrighty. Well, that's actually not seeming much better. La 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 la. Waiting. Law and crime need to get their act together.
That is the only reasonable conclusion.
Alrighty.
Was Matthew Terry angry? Yeah.
Alrighty, we are ready to go. We are ready to rock and roll. Let's see if this is any better. Hopefully it is. It was better the last time we did this. So hopefully it'll be better this time. I just want to have there be as little buffering problems as possible coming out of Law and Crime. We've got our subtitles on. We have our volume boosted up to 400%. And this volume will probably be a little bit different than the other one. So let's go. We're bringing it back up, and let's go.
Matthew Terry didn't kill Kay Baker, and there is not one piece of evidence that they have presented with their 31 witnesses and their 70 exhibits that changes that. He didn't do this, and they haven't proven that he did. Remember, I don't have to prove anything. They have to prove this case beyond and to the exclusion of
Correct.
every reasonable doubt. And I'm going to show you why they haven't. Even if I tell you nothing, you would still have to examine whether they've met that extraordinarily high burden. Remember, we talked about the line, where you, as the jurors, get to determine where the line for beyond a reasonable doubt is. And if you get here and you say, look, this is my line for beyond a reasonable doubt, and if they're even slightly back from it, you must.
Yes, the verdict was yesterday, so that's why we're watching this. Then we're going to watch the verdict. No spoilers.
Back than that. We're not even close. But remember that visual. Slightly back from that line. Right here. You must vote not guilty. The state said a lot during their closing. They said Matthew Terry wanted to control Kay Baker. They said he wanted to have her under their thumb. Where's the evidence of that? Where's the evidence of anything they claim?
Well, the evidence of that is she goes to the bathroom, he follows her. She leaves the bathroom, he follows her. He goes to the other table, he follows her.
Heard past 11:56 p.m. Past that last text of "It's all good now." As of 11:56 p.m., the evidence shows that there was nothing going on, nothing wrong. Now, we're going to go through every single one of those witnesses, 31, and by the time we're done, you're going to see why there is no evidence.
And she doesn't have to go through every single one of the 31 witnesses and critique their
To
testimony.
the exclusion of every reasonable doubt. I want to start first, though, by talking about the instruction that the state put up in regard to what they have to prove here, because they're claiming that this is first-degree murder. There we go. Even if you accepted their version as true, which for 1 second I will ask you to do just to look at this. He's not guilty of first-degree murder. There has been no evidence presented about any reflection. So even if you accept their version, he cannot be guilty of first-degree murder.
Oh,
The law requires the period of time for premeditation to allow for reflection.
yes, the law requires the period of time for reflection. It doesn't require that he reflects. It requires that he has time to reflect.
This wasn't justifiable homicide. This wasn't heat of passion. He didn't walk in on her with another man. How do we know that? We know nothing because they haven't given you any evidence of what actually happened in the 30 minutes after that all good now text. So this cannot be first-degree murder, even if you believe their theory. And that is all that this is. It is a theory that they've presented to you. No evidence, just a theory.
Yes,
So
we're
let's talk
rewatching
about
because some
the
people
31
didn't see it.
witnesses. The
Because
first
they
one
were
I wanted
watching
to dispense
Brooks,
with
and
really
because I
ties
was
in the
mostly
second one,
asleep.
too. Michelle Rogers and Detective Crumback. Detective Crumback just came in to show you the photographs of the two knives, really one knife. But remember, there were actually two there. There was a knife that was outside and two knives that were missing from the butcher block. What happened with that other knife?
He stabbed her in the neck
Perhaps
and
Matthew
himself
Perry
and then
was
threw it
defending
away?
himself then. There was another knife missing. But we don't even need to get into the weeds to discuss Michelle Rogers and how inconsequential her testimony was.
Yeah, I don't think
Why
her
did they
testimony was
put on Michelle Rogers?
inconsequential.
What does that have to do with Kay Baker?
All right. What does the other woman that was stabbed in the neck by a drunken defense? Lovely. Yeah, he likes to get stabby. It shows that when he stabs women, he tends to stab them in the face. It shows he's done it before. Oh, perfect time. Perfect timing for Steve and Gosney to join us. Welcome, Steve and Gosney. How are you?
Good, thank you. Can you hear me?
We can hear you just perfectly.
So, yeah, I wanted to catch this because I bopped into the Brooks trial. That was a mistake.
Yeah.
And
we watched that. We watched, real quickly. Is Jeff's internet still being updated? Yeah. Believe it or not, the technician guy, there's two things that are supposed to happen in this internet upgrade. But I mean, it was already a super fast internet anyway, but they gave me a free upgrade randomly yesterday, so I took it. The technician is supposed to come and replace the hardware, and two, they're supposed to send me a magic code from the internet service provider that I have to follow through. Shocker of all shockers, the service guy didn't show up this morning, and double shocker, the phone company never sent the code for me to activate. So yeah, we're still in this legal limbo. If law and crime buffers, that's their problem. If I freeze, that's totally on me. But yeah, so that's that deal. Yeah, we during our breaks, we popped into the Brooks trial for about 30 seconds at a time. Then it was just like really depressing and tear jerking, and we just had to stop watching it.
Yeah, and I hate it. I tell you, I try to come on these things when I have something to say or add, and because this is a hobby for me,
Yeah.
and it's actually quite instructive. These trials, I like also to watch things that educate me and benefit me, and this trial, I'm just thrilled, and I'm really thank you for letting me on and talk about these, because this case is wonderful. I mean, wonderful as far as trial work. I mean,
Yeah.
I mean, it's like a doctor comes in and says, "Look at this cancer. This is really interesting. I'm going to bring in my colleagues to look at this cancer." Right?
Yeah.
But it's true. I mean, these lawyers are really brilliant. I like all of them. I like the defense. I like the state. I like the judge. And it's an interesting fact case. Although I think the guilt is pretty strong. I mean, I would say the guilt is overwhelming here. It's a very strong state case. It's still fun to watch good lawyers at work. And there was one thing. I've just popped in, and I just woke up. I'll tell you, I'm still recovering from that trip I had.
Yeah.
Oh, it was hell on wheels, that trip. But anyway, because I was delayed, I was supposed to be back on Tuesday night. I come back Saturday night. Tuesday morning, come back Saturday night. I was in airports. Anyways, the one thing I picked up, I just got on the computer and just dialed in. I saw your email. I thought I'd jump in, and I caught a little piece of the closing of this woman doing the defense closing. Right, so we've already done a state closing. So this is the defense.
Yeah, this is just the very beginning.
Well, the one thing I wanted to observe, and it's interesting because I heard your comment, which was it only takes an instant. So she asked for the second-degree murder, saying there needs to be contemplation. Well, see, that's a big problem. And this is a big problem in the law. And you are correct generally that, and prosecutors love to repeat this statement. And that is that all it takes is just a little finger on the trigger and enough time to contemplate the decision to pull the trigger, right?
Mm-hmm.
Okay, well, the problem with that theory, and that is usually let go. The problem with that theory is that first degree murder swallows up completely heat of passion. There is no heat of passion crime because everybody will have that commodum of contemplation, because a heat of passion should be a murder committed in a rage, right? A rage that somehow dulls the brain and dulls the mental acuity as sufficient to commit a lesser type of murder. Now, there's an argument, the model penal code, which is the academic view on this, is that there should be no distinction between first degree murder by heat of passion or first degree murder by contemplation, because that doesn't necessarily indicate enhanced severity. For example, a husband who kills his wife in a mercy killing because she's in pain and dying, as opposed to somebody who stalks and murders a guard, right, out of planning. One is not necessarily worse than or kills a guard because he's angry because the guard said something, right? So yeah, heat of passion in the guard killing, but not in the husband-wife killing. But the husband-wife killing, you would say, was less severe, less serious than the murder of the prison guard, right? So there's that issue. So the model penal code just wipes out this distinction. But there's this thing about it just takes a moment to come up with first degree murder intent, I think is a problem. There's one other thing I wanted to say about this, and this is a lot. See, I just tuned in and I got all this, right? That's why I said I got to come in on your show.
Well, as soon as you finish this, I'm going to ask you two questions.
Okay. Well, the second point is that there's also a difference between the contemplation required for first degree murder as an intent element, right? The premeditation required for first degree murder, and the cold, calculating, and premeditated enhancement under the first degree murder death penalty enhancement aggravator. All right. So those are two different things. So on the one hand, you've got, is the mental acuity sufficient to commit first degree murder? Probably yes in this case. All right. But then the question becomes, is this also sufficient for the cold, calculating, and premeditated aggravator under the death penalty policy? And this is, I would say, probably not, given these facts. So she might be setting up a death penalty question, death penalty, arguing against that aggravator in her closing for the on this guilt phase for her penalty phase argument.
Okay, and everybody, really quick, this is Steve N. Gosney. He is an assistant public defender extraordinaire who deals with death penalty appellate cases.
And
is that an accurate summation?
Yes, and I also assist in strategy and jury selections, and I'm trained in jury selections for capital. I'm really kind of just getting started on that stuff. The thing is, the amount of work it takes to get just started. Death is different.
Yeah.
It's extremely complex and not for everybody, that's for sure. Oh, yeah, he's got my book.
And if you go to crimelaw.net, which is right there under his handsome mug over there, you can order his book, Ideas and Answers in Law. So go make sure you do that. And like my video here, what do we got going? Currently we have 1,061 viewers and 566 likes. We need to double that. Let's double those likes. Let's get up to 1,000 likes. While we're talking here, we're going to talk for about maybe one or two more minutes, then we're going to get back into this. We have a lot of people that didn't see this yesterday that are, please hurry before someone spoils it. Please nobody put any spoilers as to what happens in the chat, because we did our poll, 778 votes. 54% of you saw this yesterday and 46% of you didn't. So literally half of the people here have not seen this and don't know what the verdict is. So there we go.
I can
No, this is not live. We're going to talk about why we're not watching. Just hang tight. This is yesterday. We're rewatching yesterday, as I said, because half of the people were watching Brooks and didn't see this, and I want to go over this with them. Number two, I was about 80% asleep by this time of the night, and three, I was waiting and hoping that this guy would show up because I know he would want to see it. Yes.
Oh, well, thank you. No, actually, I thought you were sleeping. I would have rather come on your stream with Ricada on that. I mean, oh, it was so hard.
Yeah.
And there's not much I can add. I mean, it's victim impact statements, and it's great that it's being televised, and I think we owe it to the victims to witness that. The thing is I've been through so many, it's so much suffering, and I try to limit that darkness in life.
Yeah, it's bad energy.
Yeah. So,
well, first question for you, Steve.
Yes.
From her. Is this a misstatement of the law? She said that he did not have, how did she word it? Because it's you have to have the time to contemplate. She said he didn't contemplate, where she took it. He had to have actually contemplated this act without reference to just simply having the time to reflect on it.
Well, but didn't she say he didn't do it? So you got kind of see. Tim, seems to me she's pursuing alternative theories here, which is always bad. I would say that it doesn't fit my style. And there's some stylistic changes that I would make to their defense, but I don't think they're going to win it regardless. But
do you think that's a misstatement, though, to say that the prosecution did not prove that he contemplated this act?
Well,
where the standard is you have the time. Yeah, they said he did not prove that he contemplated it.
If they say he didn't do it, then he didn't have time that he didn't contemplate it, right? So they did. When did they ever prove that he contemplated the act? That's a good question, because.
But do you need to prove that he contemplated? Yeah, you need to have the mens rea, I guess.
Well, and I think one of the problems with the state case, especially with a blood expert, is that they were trying to prove too much. They have to prove the elements, and they should have focused on the elements. I didn't see the first opening, and I actually I'm always more interested in the second opening second closing of the state, because the second closing of the state is where they cheat. So I always like to double check their cheating level, because pros so far they've been pretty good. They've wanted to cheat a couple times, but the judges shut them down. So I want to know if they're going to try to cheat in closing. I have an article on that.
All right. And I talked so long, I forgot what the second thing I was going to ask you was. So if I remember later on, we'll ask.
Write it down. I always have little notes and stick them all over the place. So.
I just assume I can remember things, and I never do.
And I just got up. I just rolled out of bed and got on the computer, and I said, "Oh, legal vices." So cheers to you, my friend.
Yep. I'm trying desperately in the last couple seconds here to think of what it was I was going to say, but I just can't remember what I was going to ask. It was an important question too.
It's okay. Think about it.
Chat,
can you remember what he was thinking?
Yeah.
Can you really know what he was thinking? You don't really know. They didn't prove what he knew.
Yeah, you're not helping me here. All right, let's get back in, and we'll pause again if I remember. So she's just started, and she's going down this, and just shut up and let's play this.
Nothing. They put her on to manipulate you into thinking they had evidence, because they don't. Michelle Rogers' incident has nothing to do with what happened to Kay Baker. Close your eyes for a second. Don't open them until you have the answer for yourself to this question. Go ahead and take a minute to close them. Ask yourself this. When we left at 5:30 last night, if you were asked to vote guilty or not guilty, how would you have voted? When you have the answer to that, open your eyes.
That's just cheesy theatrics.
If your answer was not guilty then, it should be not guilty now. Because Michelle Rogers' testimony means zero to what happened to Kay Baker. She had nothing to do with this. And they brought her in to try to manipulate you into thinking there was evidence of Kay Baker's murder when there isn't. Let's talk about a few things that did come out during Michelle's testimony, though. Ms. Rogers conveniently remembers everything about what occurred except what started the incident, going back to my comment about 2 knives being missing. Perhaps what she doesn't want to tell you is he was defending himself then. Ms. Rogers tried to claim she wasn't drunk, but when confronted with her prior statements, admitted she was well over the legal limit, about 1.5 times over the legal limit, in fact. She tried to say that she hadn't previously stumbled and fell when she went to Matthew's parents' house in order to pick up their child, who she then drove after being drunk home. Then she had to admit, well, yeah, I guess I did say previously I stumbled and fell. She tried to say, oh, maybe I corrected that in one of my multiple versions later, but she admitted right after it occurred, she did tell people, yes, I did stumble and fall. She tried to say she was just upset. When she was asked if she was angry, she tried to downplay that and said no, until she was shown a transcript where she actually had previously said she was, quote, pissed off. That's certainly more than upset. She tried to say she didn't ask for more than $250,000 in compensation until she was shown the spreadsheet she herself put together asking for over $250,000. And then she slipped in that she only got 13 to 14. I submit to you that's why she was here. Because the woman who said, quote, she was pissed off is still pissed off. Because she got $13,000 to $14,000 from Matthew Terry when what she wanted was $250,000. Don't let her testimony and their manipulation using her change what you knew at 5:30 last night. And that is that they have no evidence that Matthew Terry did anything to Kay Baker. So really, out of the 31, we have 29. And we're going to go through each one, and you'll see why there is still, even with 29 witnesses and 70 exhibits, zero evidence that Matthew Terry harmed Kay Baker.
I don't know.
Remember,
Yeah,
this is
zero
the
might be a little bit of a stretch.
The woman he loved, the woman he moved here to be with. The woman Kelly and Sean Andrews told you he went out with them every other weekend. The woman they had no thought there was going to come any harm to.
If she's going to make
When
this
they
kind of
left
argument,
Yeah.
she should not
She's
be the
someone
attorney
you
on
love.
the penalty phase.
And nothing they have presented
Her teammates
changes
there will be
that
penalty
fact.
phase lawyers because she's losing credibility here. I'm just saying.
Okay,
I'm
yeah.
sorry. I'm just. I'm jumping in. But it's like
No.
this is very aggressive. Not guilty. Ask right. I don't think that's justified by the evidence. I'd be going for second-degree murder. It may be client. The client may not allow you to do that. So if the client says no, then you got to go with what she's doing. But if she is doing this, I would definitely have a second attorney doing penalty phase because the jury's going to disbelieve you. They're going to reject you. You're going to lose credibility, and you're going to want to have a different face making the penalty phase arguments. Just a note there. Sorry,
I did remember what I was going to ask you about. It was about the reflection and contemplation part of the first-degree murder. The prosecution, was this a good thing? Do you think it was effective? Do you think it's correct? In as short an answer as possible. We know how we love to talk.
Oh, is it?
What he said in his statement to I guess bolster the view that he had the opportunity and did. He said every time he stabbed her, he had to make the reflection and decision to stab her again.
Yes.
He contemplated each and every stab wound. So even if he stabbed once and thought about it and did it again, that shows he had the intent to do it. Is that a good, valid argument, do you think?
I'll tell you what, let me come back to that. I've got some more
Okay.
information on that. That's a complex question. I think that as a that is oftentimes stated as the law, all right, in Florida. Now, there's a lot of I think it's wrong. There's a lot of problems. There's huge essays on this issue about how first-degree murder has completely swallowed second-degree or hate of passion murder because of this de minimis contemplation. Traditionally, it would not be true. Traditionally, it would not be true. What the state of law is at this point, let me see if I can pull something up real quick about that. I'm not sure if I can maybe send it in private chat while while it's playing, and then I'll give you. It'll be a little clearer like mud. So that's the question. And what I should probably do is pull the jury instructions. So go ahead and play the thing, and I'll do a little research here.
First witness I want to talk about
But
is
pay
Dr.
attention to her
Perkins.
arguments,
She was the
too.
medical examiner. She did the autopsy of Kay Baker. She said that the blood doesn't tell us anything except that Kay Baker was there. Of course, we know that. That is where Kay Baker was killed. No one's disputing that. No one's saying she was moved or the body was manipulated in any way. She said that she doesn't know if all the blood was Kay's or if there were two victims. Well, we know there were two victims because the DNA shows Matthew Terry was injured, and in fact, his blood was found on the scene. She indicated that she doesn't know if all the blood was one or two victims or if a third or fourth person was involved. Remember that. No indications that prevent a third or fourth person being involved. She also testified that nothing that she had to say tells us anything about who committed the murder. And the reality is that's the question here. Who did this? Not whose blood there is. We know whose blood there is. It's Kay Baker's blood and Matthew Terry's blood because they were both attacked. The question is who killed Kay Baker? Dr. Perkins told us that there was nothing about her testimony or about the injuries that could tell us the sequencing of events, so we don't know exactly how any of the wounds actually occurred. She testified that the wounds could have been inflicted in seconds. That's important because of Jonathan Spiggin's testimony, which we'll get to in just a moment. But remember that. All of those wounds could have been inflicted in seconds. And she told you that she can't tell you.
Flux
if
is so
Matthew
glad
Terry's
Steve is here.
wounds
He's
were
just a
inflicted by
treasure.
another.
Steve, your commentary
She
and personality are a
doesn't
breath
know.
of fresh air.
They want to imply that they may be self-inflicted. But remember, Dr. Perkins, Dr. Devers, nobody could say that those wounds were self-inflicted. Why? Because they weren't. Remember, they have the burden. If something's unanswered, you can't give them the benefit of the doubt and go, well, maybe they're right. They have to prove it beyond and to the exclusion of every reasonable doubt. The next witness was Dr. Devers, and I mentioned her as I was talking about Dr. Perkins' testimony. Same thing. Dr. Devers indicated that she can't say either whether Matthew Terry's wounds were self-inflicted or inflicted by another. Again, that means it is just as plausible that they were inflicted by a third or fourth person. You cannot give the state the benefit of the doubt when they haven't presented you the evidence. The next is Dr. Mendoza. Dr. Mendoza is the ER doctor who actually treated Matthew Terry. She told you that she too, even though she treated him, saw him in person, she can't give any opinion as to whether those wounds were self-inflicted or inflicted by another. She told you that there were notations in the records about self-infliction, but that could have just been something that needed to be ruled out, not an opinion. She was quite clear she had no opinion in that regard. She said that sometimes there was confusion when Matthew was brought in, and that doctors sometimes are actually assigned to one patient because someone improperly clicked on it, assigned to the wrong patient. Nurses have this happen, and those things get put in those medical records. They're not accurate. She also indicated, in fact, that sometimes the information that ends up in those records are things that come from EMS or the police officers, and that those things are not right. The notation about Matthew Terry saying he did this to himself is wrong. That came from the police officers, just like Dr. Mendoza said occurs. How do we know that? We'll get to that when we talk about how he was found. and what the police did when they found Matthew Terry. But remember Dr. Mendoza's words about how EMS and police officers give information that sometimes ends up in the medical records and turns out to be inaccurate. She also indicated that Matthew Terry's wounds were such that they went through skin, fat, fascia, a layer of sinew, platysema, which is a layer of muscle, and then into the sternocleidomastoid muscle. This was not some little nick. This wasn't just, oh, he's going to pretend to be injured. Remember all of the layers that had to go through for Matthew Terry to end up needing surgery for his wounds.
I hate
He
the
had
word fascia.
surgery. These were serious,
And sinew.
very significant wounds, as you can tell from all the blood you saw all over him in the photographs. The next witness was crime scene tech Janicek.
Yeah, and she's
Crime scene tech
conveniently
Janicek took photos
ignoring
and
the fact that
collected
the
swabs.
police, that the medical
purpose of
report said that
not
he
just
was
so
being
that you
treated
have the
for
photographs to look
attempted
at,
suicide.
But really is to look
Well,
at the damage.
but
Now,
things get in
the state
reports,
wants to
you know.
tell you, oh, there's damage to a bathroom door and there's damage to a bedroom door, and that must mean that there was a fight inside the house. No, it doesn't. You heard no testimony about a fight inside that house. How do we know that that damage wasn't there for months? How do we know that that isn't damage left by a landlord who just doesn't really care about keeping up the property? They've presented no evidence. Now, one thing to posit though, is that third door, the door that was locked, the door that goes into the bedroom that had the window screen out. That wasn't kicked in. Think about that for a moment. Their version is that Matthew Terry kicked in a bathroom door, kicked in a bedroom door, but then stopped, didn't kick in the door where Kay Baker was barricaded? Does that make any sense?
Yes, if he knew that she was
If he kicked
outside
in the
and ran
bathroom
outside
door,
and
kicked in
stabbed
the
her
bedroom door, and
repeatedly.
she barricades
Now,
herself in
careful
that
now.
bedroom.
Don't get biased.
He kicking in that door too?
She's got a tough job. Let her
Wouldn't
do
that
it.
make more sense? That's not what happened.
Oh, she's outside. Let me kick the door in.
That damage
I'm
to
biased.
the bathroom door and to the other bedroom door is old, and there's no proof to the contrary. None.
I want to talk about doing these
And
type
not give them
closings.
the benefit of the doubt. They have the burden. Remember,
I like
there's
her.
no
I like this
disarray in
defense attorney a lot.
photographs
I
of
think
that
she's
house.
great.
There's
Okay.
nothing knocked
I mean,
over.
really,
There's
the
no blood
argument's
other than
weak,
the
but
blood
she's
that
presenting
the
it with passion.
new officer accidentally.
I'm sorry. I'm just like I really respect these people because this is a hard
There's
argument.
no ins-
What was that? It's a hard
I'd say
argument.
it was a hard argument. I've been in this
Yeah.
woman's place, and you have to I was going to say you have to put yourself in war mode. Yeah, we are replaying it so we can stop a little bit. You have to. I call it war mode, and there's a point at which when you're getting ready for trial. Like I'm very analytical. I'm very much like that's a stupid argument, right?
Yeah.
But once you've decided you're going to go and you've made the strategy and you know what you got to do and you're going forward, right? You got to put your blinders on and you got to just believe what you're saying. You got to convince yourself that they did not prove it beyond a reasonable doubt. You don't have to believe a lie, but you can doubt the state's evidence, even though it's a mountain, and you have to convince it because if you don't believe it, the jury won't believe it. And so,
good.
you know,
Keep
so
that in mind.
I have to put my hat on, and I call it war mode. And the problem is that you get blind because you are all of a sudden you lose your objectivity because there is no objectivity. You got to represent your client. You got to do your best in your arguments. Usually it happens about a day or two before the jury trial when I finally get my brain in like war mode. And then it's like everything they say is crap. You know? And so I'm appreciative. I know that that's what she's done here. And I respect it. It's a trial. You have to do it as a public defender. And a lot of it's just like, I don't believe any of their evidence. You know, I'm not convinced. And you know, skepticism is something we bring to the table as lawyers. And you know, there's a lot of evidence to be skeptical about in this one, but I respect her as a lawyer for having to do this, and she's presenting it well. That means she's got her war mode hat on, and she believes what she's saying. I'm sorry, it's going on.
I say, well, let's keep that in mind. Let's keep that.
So don't be
healthy
so hard
skepticism.
on her. I guess I know, be so hard on her. She's doing good when she's believing what she says. I'm not saying I believe it. I think I hate to say this to my fellow public defender, but I think that state's got this one, but
Well, let's talk to
she's
see if you
doing
still
good.
have this same idea, say 15 minutes from now.
Oh, do you have
Really
something, know
curious.
something I know? All right, keep going. Let's go.
Yeah, I've seen this. That's what
All
I
right.
know.
All right.
Execution says Steve is a 40-year-old Tintin. Just kidding. Oh, you
What's
ever see
Tintin?
Tintin?
Rin
It's an old
Tin?
animated show. It's about a boy named Tintin. You
There
can
was
Google
Rin
it.
Tin. I used to watch
Rin
Rin
Tintin's
Tin.
the dog. Yeah,
I
this
like Rin
this is just a boy named Tintin. If you Google it, you'll see why they're saying that to you.
Okay.
You kind of have the same hairstyle and kind of the same garishly boyish looks as Tintin does.
You know how old I am? Let's not go there.
Michelle Cavernos, thank you so much for the $1 super chat.
Are these really all pretty girls sending money? Or is that just
yeah.
No, I'm psyched.
That's how Legal Vices rolls.
The internet doesn't lie.
No, never. But in their case, of course not. Sonia or Chris, this is the same BS the ambulance chasers say about EMS medical records. Really grinds my gears. The reason the information changes is the patient changes the story. That's the Dr. House motto, isn't it? All patients lie. Well, let's see how this holds up, because the next question I'm going to ask is a little bit down the road from you here.
Okay, I need to make notes because I'm doing some research. That was just popping up in my head. I'm sorry, I'm interrupting.
No problem.
It's your stream, so if I'm out of line, yell at me.
Yes, Flux, we read yours. You're not paying attention. Go to the bad girls room. I'll be there in a minute. But I have to fight off your wife first, so never mind.
Incident that occurred inside that home. No evidence whatsoever that there was any incident in that home. Now, they, of course, will want to say, oh, look at the hanger. Are you kidding? There's a hanger that's bent, so we are supposed to assume more assumptions they're asking you to make. We're supposed to assume that somebody who kicked in a bathroom door and kicked in another bedroom door stopped and said, oh, maybe I'll just try to use this hanger to get into where she's barricaded and give her lots of time to get out the window. That makes no sense.
This
There
is
was a
literally the
bent
Chewbacca
hanger.
defense.
Who cares? That doesn't
gotta have
It makes no sense.
about what occurred. And certainly, there's been no proof
reasonable doubt
that hanger was used for anything at all. The next witness was Detective Watson. He took a swab of Matthew Terry. Doesn't really tell you anything. The DNA will, of course, talk about when we get to those witnesses. Deputy Bateman, he's the person who took the aviation video that you may recall. It's the video that had the blur of light. That was where, how they were able to get to Matthew Terry. Well, he told you that he got a GPS location to immediately go there. So there's no indication that there was ever any ability to look for other suspects. It wouldn't have mattered by then. It's 5 hours later. Remember the testimony earlier? It took the police an hour to put up a perimeter. 15 minutes to even respond. Whoever did this was long gone by then. But even if they hadn't been, even if it had been a quicker response, aviation, he went directly there. No opportunity to look for other hotspots, other people. Next witness was crime scene tech Douglas. He indicated that, well, they didn't bother to use the Faro system in order to create a crime scene diagram. Their drone photos didn't save for whatever reason. They didn't bother to process the window screen, the screen that the state is relying on to tell you that, oh, Kay Baker must have gone out that must have been her pathway. That's how she tried to escape. They didn't bother to look for prints or DNA there. They didn't even bother looking for footprints. Kay Baker is barefoot. Matthew Terry is barefoot. Did they try to look for footprints? He tells you they didn't even do that. He did indicate, though, that he took a swab from every marker, and not every marker, as we know from later testimony from Detective Redo, was tested. 50 items. They tested 10. They tried to say, oh, we have a procedure. We can only submit 5 at a time. That's ridiculous. He told you all they have to do is ask to submit more. They have.
And you mentioned that was incorrect, but that in a death penalty case where the right to a speedy trial has not been waived, that you can pretty much get anything tested anytime you want if you ask. Is that correct?
Yes, yeah, they can expedite testing in, especially in first degree murder charges. I mean, there's a limit to control because you get, testing happy investigators who come into a burglary, or a killing of a deer, and they want 50 things tested by the DNA tested, and so they have that 5 limit rule. But in a first degree murder trial, if they say to FDLE, we got speedy trial on this, it's first degree murder, FDLE will exceed their thing, will do it fast. And I've done it before many times, and they're very good about that. So
score 1 for the prosecution here, for the defense. Score 1 for the defense here.
Well, I gotta get once in a while. Give us a couple bones.
She is correct.
Have to have a reason, he said. Yeah, like a murder trial coming up. They didn't bother. Just like they didn't bother with the Pharaoh. Just like they didn't bother with the drone or having the drone photos in a manner that would reasonably save. Just like they didn't bother to test the screen for fingerprints or DNA. Just like they didn't bother to look for footprints. They didn't bother. Why? Because they assumed it was Matthew Terry, which is obvious when we get to the officers who actually located him and what they did. But first, let's talk about the 2 first responding officers, Deputy Ellis and Deputy Strahan. People are new. They make mistakes. But Deputy Ellis actually transfers blood from Kay into the home, and Deputy Strahan was brand new in his job supervising her. So the first 2 people who get there are brand new in their positions, and some mistakes were made. In addition, though, I would just point out, there's really nothing to their testimony that changes the fact that the state has presented 0 about who committed this crime. The only thing that they testified to was finding Kay Baker's body. Again, we don't dispute that Kay Baker was there. We signed a stipulation. That is her. We're not saying the body was moved or manipulated in any way. And then they end up going into the residence. But again, no signs of any struggle in that residence. No blood, nothing. The next witness is the neighbor, Douglas Hicks. Well, he tried to say during his testimony that he heard crying or yelling out, but then he admitted that when he originally had reported all of this, he actually had his TV on, and he had previously said it was only gasping and gurgling that he heard. And remember, Ruth Figgins said he was actually drunk that night. So his explanation of crying or yelling really isn't reasonable. What he said that night is it was gurgling or gasping, which we don't dispute. I'm sure Kay Baker, from her very serious injuries, was gurgling and gasping. That doesn't tell you anything about who did this. Jonathan Figgins, he's the one who tried to help her, the husband of the 911 caller, Ruth Figgins. The state said during their opening, well, Jonathan Figgins put on his lights, and that's what made Matthew go in the other direction. How would that have occurred in those seconds? Think about that. If Matthew suddenly gets there, lights go on, why would he go back into the yard? And if he did, just to immediately go to the area where they claim he went to try to get around? How would all of this have happened? Remember the testimony in regard to all of the pink spots on this chart that was their expert's chart are the unknown things, the things that aren't tested. They want you to believe that he gets to you, lights go on, and he goes, I better not go that way, there's lights. So he decides to run back down to O, then run across this way, and then hang out up here a little bit, because remember, there was testimony about the concentration of blood being bigger in this area where there's D, G, E, F, H, A, B, C, and then cross over and go that way. Why?
It's almost like he was trying not to get caught.
Would that make any sense? Think about it. If their version is true, if Matthew Terry gets to you and suddenly lights go on, what would make more sense for him to do? Get down in that brush. Go directly that way to Lithia Pinecrest and get the heck out of there. Their version, yet again, doesn't make sense. By their own evidence, by what their own expert said, doesn't make sense.
doesn't make any sense at all.
But what Jonathan Figgins did tell us, and what makes much more sense, is that it took him up to 3 minutes to get outside after hearing that first thud, because he checked on his daughter, he had to make sure it wasn't her, he thought she had fallen out of bed, that it's very dark behind his house and it backs up to Lithia Pinecrest. He indicated that he heard a noise once he got out there. 3 minutes later, he heard a noise in the woods that could have actually been 2 or 3 people. And that Lithia Pinecrest is a very busy road, and you can walk to Lithia Pinecrest in just seconds. Why does that matter? Put this back up just for you to see for a second. DD, S, R, those are the areas right around where Kay Baker was found. If he heard a thud at that time frame when Kay Baker gets hurt, and it takes him about 3 minutes to get up there, it's not going to be just the seconds that the state's theory says Matthew Terry would have gone to you, and then somehow, for whatever reason, they claim go this way. That makes no sense. What makes more sense is in those 3 minutes, all of this back here is happening. You'll understand that when I get through their witnesses and why their witnesses don't point to Matthew Terry, and I tell you what actually happened. But remember this, 3 minutes is how long this could have taken. Not
Okay, this is where I have the first question for you.
Okay.
And see how your thoughts develop as this goes along.
Okay, good, because I'm like doing research and my
yeah.
brain is not, I'm not as tuned in, so I will stop doing research and do tune in.
Stop doing research and pay attention to this. Right. This is where I think she starts to lose the plot entirely.
Okay, all right, let's, because
she's saying this whole this doesn't make sense. None of this makes sense.
I'm very much sensing that she is bought into the case theory, right? She's overcommitted. This is why you want to have a team to check you and to try these arguments out, because like I said, my choice in here would be to try to work on the premeditation question, which I've given you lots of stuff in the private chat about. That's the actual premeditation versus heat of passion jury instruction, along with a case that talks about that. And there's a legal appellate issue here too, but she's bought in. So let's go ahead and let's lay on the over closing.
and for the record, Steve has not watched the closing arguments, and I'm assuming you don't know the verdict, or do you know the verdict? We're not giving spoilers, so
I'm not
no spoilers.
I take the fifth.
Okay, all right. Well, have you had the honor of seeing South Park's Chewbacca defense?
I've only seen the snippet, but I get it.
Yeah,
I don't think this is the Chewbacca defense. It's
totally the Chewbacca defense.
No,
Chewbacca's a Wookiee from the planet Kashyyyk.
No.
Why would a Wookiee, an 8-foot-tall Wookiee, want to live on Endor with a bunch of 3-foot-tall Wookiees? It makes no sense. She's literally giving the Chewbacca defense.
Well, maybe
it
coming
makes
up.
No sense.
We have an office. I have an office mate up in Flagler who is the master at the Chewbacca defense. She is unbelievable. So I've seen the Chewbacca defense work, and I don't think this is it. But go ahead, lay it on.
And did they blood test him for mens rea? That's funny.
Let me explain why they didn't ask for more blood tests from FDLE. Because you've got a trail of 50 spots.
Yeah.
And it's like, well, this one and this one and this one and this one are all him, right? And it forms a trail, right? Is it like somebody else is running in there and bleeding along just to, I mean, at some point it's like, okay, we get it. Go ahead.
Have you seen the it's Gene Wilder? It's a Gene Wilder movie with Richard Pryor called Hear No Evil, See No Evil.
I think I've seen that one. I want to see. I love those two. I love
Gene Wilder is deaf, and Richard Pryor is blind, and they get accused of murder. And why this is funny is that's a clip from the movie that I play at the beginning of my murder trial shows, which goes like this.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea.
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Oh, I gotta see that. I love it. I love it.
Yeah, so that was where that chat came from.
Have you ever seen Johnny Dangerously?
Yes. Yeah.
You know, where he's like, you know, videotapes, depositions, you know, video surveillance. It's like, it's weak, it's flawed, it's not enough. You know, it wouldn't hold up in a court of law. That's my favorite. Whenever I think about this, like being this defense attorney, it's like, you know, we got blood stains, we got DNA, we've got stab wounds, we've got this. It's not enough. It wouldn't hold up in a court of law, you know.
And Givener says, if he was not guilty, would he have not just gone to the lights for help?
Well, he was hurt. He was injured. He was in the bushes. He was attacked. He was confused.
Oh, we're getting there. Just hold tight for that. That's exactly where we're going.
Oh,
Flux, I love that she just calls everyone drunk or incompetent. Well, see, and that's why I'm thinking she's going down the wrong path already. She said she's going to address every single witness and their statements. So this is like that group of, you sit with a group of 10 people and one person is complaining about how everyone else is crazy but her. And the other, okay, if we're all crazy and she's not, we know what that really means. So she's just chucking all 31 witnesses under the bus, basically. Why they're all absolutely wrong.
It wouldn't hold up in a court of law. It's not enough.
Legal Advice says, what about the stabby really wanting to testify, but he's going to go with his lawyer's advice? Yeah, after we finish this, we might want to go back and get to where the judge asks him if he wants to testify. His answer was, I really want to testify, but on the advice of my counsel, I'm going to follow the advice of my counsel and not testify. And the judge said, that's not how we answer this question. Let's go over this again. And he really held him to it until he said, yes, I do not want to testify.
Good judge.
The judge wouldn't let him off with that. I want to, but I've decided I'm going to listen to my lawyers who don't want me to. So that was, well, I have to go back and listen to that.
The lawyers tell him that answer that way so that he can preserve appellate issues in the future, so that way he can accuse his lawyers of being incompetent. And then he says, well, I followed their advice and they were wrong and I can accuse them. So I don't like it when the judge asks, a lot of times they'll say, are you happy with the services of your lawyer? That is not a proper question. Now, it is a proper question in the right to testify, because that is singularly the client's call. It is not the lawyer's call. The client has the right to testify or not testify on their own call. They don't have, whether they're satisfied, that's just a way to undermine future appellate issues. So the lawyers are telling him to answer that way to give him wiggle room on appeal.
And the judge would not let him get away with it.
Smart judge. He's a good judge.
The judge pressed him until he said, yes, you are right. I do not want to do this. So that was good. But now the question I'm going to ask you is, what she's doing here, going back to what you said, create skepticism in the prosecution's arguments.
In the defense arguments.
No, the defense wants to create. They want to raise skepticism about the prosecution's case.
Oh, okay.
On defense,
they're trying.
Yeah, but But she's gone from. This is right where she crosses the line. From, okay, let's be skeptical about all these witnesses they put up. Let's be skeptical about the evidence. And she just said the magic words, I'm going to tell you what really happened.
Yeah, that's called a burden shift, and that's a mistake, and that's a problem it's easy to do that, but you don't want to bring on, I will have to prove anything. Okay, you're shifting the burden of proof back over to the defense, and that's usually a mistake. So let's hear the way she says that. Yep,
then that strap in, because she's going to present her theory of what really happened over the next several minutes here. Yeah. All righty. Be share here and turn back time. All right.
Matthew Terry, and I tell you what actually happened. But remember this.
I will tell you what actually happened.
Is how long this could have taken. Not the seconds the state claims, where Matthew Terry just got to you and said, "Ooh, lights are on, I better get out of there." Didn't happen that quick. Jonathan Figgins told us that. It took him up to 3 minutes to get out there. A long time for a whole lot to happen. Now, Ruth Figgins, his wife, she's the one who actually called 911, she indicated that she heard nothing before her husband alerted her to what was going on. She said, as you can actually hear on the 911 call, that it took 15 minutes for that first officer to arrive. Plenty of time for the person who actually murdered Kay Baker to get out of there. She indicated that Kay Baker's feet were dirty. You actually could see that in the photographs. Why does that matter? It matters because Kay had gotten home calmly with Matthew. Matthew, by the way, was barefoot too when he was found, because they got home, took off their shoes. Nothing was happening between them. Matthew's keys are by the bed. His car's in the driveway. They're going to sleep. He's in his underwear. As the state mentioned, Kay Baker had taken her bra off because they're going to bed. There's no ongoing argument like they want you to also believe.
What happened? Frozen? Hello?
Hang on. Okay, we're back. Hi,
There we go.
everybody. I just paused it there while we were off in limbo. We're back now. That one's on me. All right, now let's go again.
I put the Johnny Dangerously clip in the chat there.
Okay, cool. All right.
And of course, Ruth also talked about Lithia Pinecrest, how big of a road it is, the fact that there is a stream that is crossable in just seconds, that opens up to a big cow field, all of which is an egress or an ingress.
We call that a pasture where I come from, not a cow field.
This crime.
Not in Florida.
We have Corporal Royal who testified. He just talked about how he got the video from the landing. So in regard to his testimony, it's just to set up the video. But let's talk about the people that are in that video, because that's really what's more important.
Oh, come
Oh,
on.
man.
The first person let's talk about is Tara Johnson. Tara didn't know what was actually going on. She was dealing with her husband, who was drunk and wanted to go home and kept bugging her, telling her, let's go, let's go, let's go. Her son was there too, also drunk, wanting to go home. She had been having...
Hey,
and
that's good.
she
Good taste.
decides to interject in the conversation between Matt, Kay, Sean, and Kelly. Now remember, you heard the testimony, and we'll talk about Sean and Kelly's testimony in just a moment. Sean and Kelly were very close friends of Matt and Kay. They can talk about that kind of thing if there were some tiff, some silliness going on. Tara didn't even know Matt. She only met him that night, but she drunkenly decides to go get involved in this.
Okay, I really apologize for pausing here, but we just wanted to make sure that I read this super chat from Just a Map Nailed to the Wall. It doesn't show up anywhere on me, but I had to go into the monetization tab in the studio, and it shows up there. For some reason, it didn't show up on my stream here in StreamYard. So, Steve, do you simulcast? Oh, do I simulcast to Rumble? If not, why? If yes, or that's all I've got. It doesn't have the rest of the message. That's where it ends. Let's see if I can get a more. Okay. Do you simulcast to Rumble? No, I don't. If no, why not? Because I haven't worked it all out yet. And it's just kind of a repository for it's my backup files is basically what it is at this point. It's my YouTube backup. If yes or no, why is there no hooded sweatshirt in the merch store? Love, Brandon. It's on its way. We'll be getting some hoodie merch. It's winter. So I just wanted to make sure that I read that. Yeah, because it didn't. It may have showed up on the actual YouTube feed, but it doesn't show up on the StreamYard feed that I was looking at. For some reason, that one just didn't show up. So thanks for mentioning that. And if you do make a super chat and I don't read it during the next lull when I'm reading other ones, let me know and I'll go back and find it like I just did there. Sorry about that. Back to our regularly scheduled program.
And she's claiming now, oh, there was some argument. Really? She didn't know him, so certainly can't judge whether he's upset or not in regard to any way that he would normally react or talk or have a conversation. She's a stranger interjecting. Why wouldn't he get annoyed by her? He wasn't mad at Kay. He was mad at Tara jumping into a private conversation she had no business jumping into. How do we know that? Well, because of the other witnesses who testified. But before we get to them, remember what Tara said. She said, in the end, everything was fine. When she left, everything was fine. They talked about getting together again for Memorial Day. She sent Kay a text saying she had a good time because everything was fine. And it wasn't the big deal that she tried to make it out to be, interjecting herself in a situation she really shouldn't have been in the first place. But as far as
That
the
old,
other witnesses,
she was killed because her
remember
friend
what
stuck
they
her
said.
nose in
Shawn
the
Andrews
argument.
told you that
No,
he
no,
and his
she's
wife
saying that.
Kelly,
I know.
No,
they
no.
were best friends with Kay. Kelly has known Kay for over a decade. He's seen Kay pretty much every other
Entertainment
weekend.
versus analysis. You
He
know.
is also now, because of Kay and Matt dating, seen Matt every other weekend for months. They're all very close. Everybody, of course, at the landing was drinking. Shawn testified that there was a discussion. He described it as heated, but said that there was no fight. There was no yelling, and then that seemed fine. But most importantly, what did Shawn say? Kay, his wife's best friend, his very close friend of over a decade, there is no way he would have let her leave if he thought there was any issue still ongoing. And he didn't, because there wasn't. There was no issue. Kelly testified, and all the sympathy in the world for Kelly. This was her best friend. Unimaginable losing your best friend in a way like this. But because of that pain, she has made what was not an issue, not an argument, as testified to by her own husband, into something bigger in her own head. So she told you, though, despite making it sound like it was an argument, that there was no yelling. Matt didn't get aggressive with Kay. There was no slapping, pushing, nothing of that sort. She said they stayed an hour after it came up, and the dancing issue didn't even come up again. She said Kay called her and yes, said he brought it up again, but when she, who is close enough to him to actually say, tell him to cut it out or I'm going to kick him in the balls, he said, okay. He didn't yell, he didn't curse, he didn't say stay out of it, he didn't get annoyed with her like he did with Tara, because Kelly and Shawn were practically family. Tara
And abusers are
was
never
for
quiet
the
in public and
moments
abusive at
of
home
the
where no one can see.
not this
ever.
silly dancing issue.
But
But
What
most
do I know?
importantly,
What do I know?
Kelly testified about that text at 11:56. It was all good by then. The text is all good now. So silly. So stupid. And that's exactly what it was. It was a silly, stupid nothing. Because next is Nicholas Calicochi. He tried to say now, and he too was very close with Kay, and in hindsight, he thinks, well, maybe it was an argument rather. So he's trying now in his own mind to rationalize what must have happened. But he told you, the night in question, he said there was no fight, no argument. He describes it as, quote, wasn't even a tiff. It was over in 2 seconds, the topic was immediately dropped, and that Matt and Kay went back to their table to have fun. And that's really what it was. It was a 2-second nothing that was immediately dropped. That's everybody who was there that night that testified. Not one reasonable indication that there was any real argument, problem, dispute. You saw the video.
Ooh, thank
There's
God we
no
have the blood evidence to clear that.
large gestures of somebody who's getting heated and upset. In fact, you see Matt go over and put his arm around Kay after it. Kay gets him a drink, or he gets her a drink. They're going on back at the table, talking, drinking, hanging out for another hour with their friends. Nothing happened. This was nothing. Let's talk about the DNA. The next witness is Alyssa Troutman. She said Matt's DNA and Kay's DNA was there. Okay. Remember during voir dire, during jury selection, I said to you, sometimes there are experts who might testify and you think, oh, they're an expert, it must be really important. But it's not on an issue that actually matters. Remember, the only question here is who killed Kay Baker. Of course Kay's DNA was there. Of course Matt's DNA was there. He was hurt too. But what she said that was interesting was that she put into StarMix that there would be 2 contributors. She didn't put in that there could be a third. And what did she say? I wrote it down. She said,
I think this is the best point the defense
"I don't
has
know what
right
the
here.
program would have done.
Yeah. The state should have
Doesn't
cleaned
know
this
what
up.
the program would have done if she put in a third person. We have no idea. And by the way, 40 pieces of evidence that they didn't even bother to submit for testing. 80% of the evidence. They submitted 10 out of 50. 80% not even bothered to be looked at. The next witness, and we're at 21 witnesses right now. Again, not one piece of evidence yet pointing to Matthew Terry. 21 is Anna Cox. She was the expert who did the map that we've shown a couple of times. She indicated that Kay's blood may have gotten on Matt as he tried to help her. Common sense, right? Jonathan Figgins got Kay's blood on him as he was trying to help her. So did Deputy Ellis. Matt did have Kay's blood on his hands. He did touch the wall where you saw the BB because he got attacked and was bleeding too, and he did stumble into the fence as you saw at the U. Because again, Kay's blood was on his hands from him trying to help her, and then when he got attacked and was bleeding, his blood was on his hands too. Anna Cox indicated that she can't exclude that if Matt had gotten Kay's blood on him trying to help her, then was attacked and touched the wall at BB, and then stumbled into the fence at U, that his and Kay's mixed DNA could have gotten on the wall and the fence that way. That's their expert. In fact, she actually talked about the directionality of the blood at BB. That's the blood on the wall, going towards the backyard. Where else is that towards? Towards you, towards the fence where he stumbled into. She indicated that there was a large concentration of blood at H. Now, just to be clear, which H, because there are 2. The H we were talking about was the one way over here. Try to zoom out to get this all in one. There we go. The H that we're talking about with the large concentration of blood is over here. Why is that important? Remember that location, and I'll tell you why that's important in just a few minutes. But she said there was a large concentration of blood there. Unfortunately, we don't know whose blood, because they didn't bother to submit it, but a large concentration near where Matt was found. We'll talk about that in just a few minutes. Ms. Cox also said that Matt had a lot of blood on him, and it might have all been his own. They didn't have it tested. We don't know if it's his blood, Kay's blood, a third person's blood, but it could have all been his own, as Ms. Cox told you. But most importantly, she said she has no opinion to offer you on who did this. And really, isn't that the only question that matters?
But really, that's not her job either.
And she cannot exclude that a third or a fourth person was involved. The next witness was Detective Ritto, the lead detective. Now, he helped look for a knife, but he didn't find one. Why is that important? Well, he told you that he looked where Kay was, he looked in the backyard, he looked where Matt was found, he looked along Lithia Pinecrest. They looked everywhere. He told you multiple deputies, multiple people using equipment, metal detectors, trying to find a knife. There wasn't one, because the real perpetrator had left with it in the 15 minutes it took for the police to get there. If Matthew Terry did this, they would have found the knife where he was laying, or somewhere close to it. Remember, we had this map. Large concentration of blood where he was found. If he did it to himself, If he cut the wounds in his neck like they want you to believe, wouldn't that have occurred where that large concentration of blood was at H, where he was found? And if that's what happened, he would have still had the knife on him or close by. They would have found it. Why do you think they didn't? Because the real perpetrator had left with it. It wasn't some ridiculously little 3-inch paring knife, little bent bird's knife. If he was going to grab a knife from that butcher block, wouldn't he have grabbed a butcher knife? Wouldn't that make more sense?
Is it
The
Chewbacca's
next
blood?
witness- Oh, a few more things from Detective Redo. He
Who said
also
that?
pointed out, and I liked the phrase he used, which is why I want to mention it.
JKD.
He said that there were indications Matt and Kay normally arrived and were getting ready for bed. I agree with that completely. There were indications Matt and Kay normally arrived home. Matt's keys to the car that is in the driveway were right by the bed. If Matthew Terry did this, wouldn't he have gotten those keys, gotten that car and left? Detective Redo told you that Kay's
'Cause that would
shoes
look
were
really
off.
guilty.
We know that because of the pictures where she was found with no shoes. Another indication of getting ready for bed. Just like Matthew Terry, his shoes were off. There was no argument going on. They were going to bed. Matthew was in his underwear because they were about to go to bed. And most importantly, of course, that text at 11:56 was that everything was fine. But he also told you that he doesn't know the circumstances of what occurred because there's no evidence of what occurred. Remember that.
It's too bad I watched the evidence portion of the
There were blood
case.
scraps that showed someone fled. Well, of course. But he doesn't know who. He told you he doesn't know who, and that's really the question that they have the burden to answer. And they haven't. And he told you that more than 50 items were collected and 10 sent for testing. 20% sent for testing. Next, we have Detective Van Gilder. He indicated that the only knife missing from the home was that little 3-inch paring knife. Again, I'd ask you to just use your common sense. If Matthew Terry grabbed a knife from that butcher block intending to harm Kay Baker, is he grabbing the smallest knife there? Is he going to grab a paring knife that's curved instead of a big steak knife or a big butcher block type knife? Of course not. It's absurd. That's not what would have occurred. Witness 24 and 25, Detective Gibson and Detective Davis. They testified that they used metal detectors and ground wands to search right where Matthew Terry was found and didn't find the knife. Again, going back to exactly what I've said before about that.
If you paid her
That
enough.
knife would have been there if Matthew Terry did this. But that also ties into the 26th witness, Deputy Polito. Deputy Polito, you might remember, he's the one who had the bloodhound. So he told you that his hound can only track the scent that is given to him. So Canine Champ could only track that one scent. If there were other scents of a third or fourth person there, he's not going to be tracking that. Deputy Polito indicated that he stopped Canine Champ because he found a large pool of blood. I submit to you that's right around the H that Anna Cox talked about, where there's that large pool of blood. And that when he pulled out Canine Champ, Deputy Gibson and others came in order to try to find the person who was there. And in fact, it was Matthew Terry, who was just right beside that large pool of blood, because that's
And never said,
where
police,
Matthew
police,
Terry's
over
neck
here,
was
help
cut
me, I've been stabbed
by
in the
the
neck
real assailant.
repeatedly, help me, I'm
Remember,
dying.
if he cut his own neck right there, they would have found that knife. They didn't. Deputy Polito also told you that Matthew Terry had to be walked out of the area by deputies, which you actually got to see on the body cam. You could see, in fact, that Matt was injured. He was staggering. He had to be supported by the next witness, who is Deputy Hall. He's number 27.
And he had a
Deputy
high blood
Hall
alcohol content.
Told you that Matt was found on his back and that another deputy immediately rolled him over and handcuffed him, despite Matthew being, as described by Deputy Hall, quote, very pale, having serious wounds to his neck, needing to be assisted to his feet, assisted in walking, and that he appeared, quote, on the verge of going unconscious, and quote, on the verge of potentially dying if medical care was not immediately given. So he did immediately get him care, got an EMS, and they transported Matthew to the hospital. Now, the deputy that had rolled Matthew over, that's Deputy Curtis. He's number 28 that we're going to talk about. Remember, though, as we talk about Deputy Curtis, what Kaylin Hall said. Matt was on the verge of dying. Deputy Curtis, though, he assumed, oh, that's got to be the killer. So he immediately rolls him over. Who cares about his injuries? Do they bother to document his injuries? Did Deputy Curtis stop for a moment to see if rolling him over might cause Matthew to die? No, he didn't care. Deputy Curtis made an assumption, immediately rolled Matthew Terry over, handcuffed him, and assumed he must have killed his girlfriend. Because the spouse, the partner, the boyfriend is always a suspect. It's an assumption, which led to the theory that the state is asking you to believe. Now, you saw it on body cam. You saw how Deputy Curtis completely disregarded Matthew's physical appearance, his lack of any ability to stand on his own, his paleness, his multiple wounds to his neck, the fact that Matt had blood coming out of his nose, blood all over him. You saw Deputy Curtis just toss him over, cuff him, and you also got to see Deputy Curtis's demeanor on the stand. Think about how he testified. He didn't even want to admit that someone could have gotten away in the hour prior to him getting to his perimeter point. Why? Because he's the one who assumed it was Matt. He's the one who immediately arrested Matt. He's the one who this whole farce was based on. The next witness, Deputy Gianni, readily admitted that someone could easily have gotten away before setting up the perimeter point an hour earlier. Deputy Curtis wouldn't even try to give any remote possibility to that, because he didn't want to accept that his assumption was dead wrong. But luckily, Deputy Gianni took photographs of Matt's injuries, so at least we have that, and we have the body cam to show you how Deputy Curtis acted in those moments. We're at 29 witnesses. Not one shred of evidence yet that Matthew Terry did this.
It's flimsy.
Let's talk about number 30. That's
the legal
crime
term.
scene detector. What did he tell you? There were 3 blood trails. One along the fence line, one along the back edge of the property, one straight across to the decedent's.
Just listen to this.
Now, I can't tell you whose blood that was because they didn't test all 50 plus swabs that they took. But it's not my job to tell you. It's theirs. It's their burden. But he did tell you there were 3 blood trails. And we're on the last witness now, Deputy King. Deputy King is who first found that screen off the window. You got to actually see it on his body cam. I'm not going to play the body cam, but I'll show you the picture of it. Remember, though, as I'm showing you this picture, what Detective Redo said when he testified. Now, I had no idea he worked burglaries. They brought that out. But what did he tell you? He said that first floor unlocked windows are points of entry for a burglary if the screen is removed. This is the state's 11E. First floor, unlocked window, screen removed. Now, the state tried to say in their opening, hey, wait a minute, no way, can't be from a burglar because there's a stuffed animal. Really? You saw the photos of the inside of that room. There were a bunch of stuffed animals there.
Inside the room.
Someone could have taken that off, gently placed it down, not stuffed animal even there yet, crawled in and knocked out with their foot one of the stuffed animals as they're crawling in. First floor, unlocked window, screen out, gently placed against it. Not frantically pushed out onto the ground like it would have been if their theory
That doesn't
were
look
true.
gently placed.
Remember, what did they tell you? They want you to believe Kay Baker, after Matthew Terry kicked in the bathroom door, kicked in the other bedroom door, chose not to kick in the door where she barricaded herself, giving her plenty of time to frantically push out the window and get out there. And then what did she do? Stop and pick up the screen to gently place it against the side of the house? That doesn't make any sense. If she were barricaded in that room, Matthew Terry would have kicked in that door too. We know that didn't happen because the deputies kicked it in to get into that room. And that screen would be further and away from that window, having her frantically pushed it out, not quietly, gently placed against the side.
Now, if I was crawling through that window, I would move it out of the way so I don't have to
prove
crawl
what happened.
over it at an angle to get in the window, just saying. But it gets better.
Okay, I don't know. This is called
We're
talking
at the end of the
points.
witnesses.
Remember Clinton talking points?
There's
Yeah.
no evidence.
It's like, okay, we can argue this.
None. Matthew Terry didn't do this. And I don't have to tell you what happened. All I have to do is raise doubt about their theory. But I'm going to tell you what happened.
Here we
And I'm
go.
going to show you how the evidence actually shows that their version is wrong. And what is a reasonable inference of what actually occurred based on the actual evidence. The things that they ignored.
Will this be a
Now-
reasonable inference?
They wanted to read to you the reasonable doubt instruction, so do I, because the part that they never mention when they read it is this part that I've highlighted. Let's see if we can zoom in a bit. They read to you the first part, because they want you to say that what I'm about to tell you
Not a
is just
shred of evidence,
speculation
Vince
and
Clortho.
imagination.
Not
No,
a
it's not.
shred of evidence.
It's a reasonable inference based on the evidence, and you are allowed to use anything that can be reasonably inferred in order to find out. If after carefully considering, comparing, and weighing all of the evidence, you do not have an abiding conviction of guilt, or if you have a conviction of guilt, it's one that's not stable,
This is
but
the
one
worst.
that wavers
It's
and
such a stupid
vacillates,
definition.
then the charge is not proved beyond every reasonable doubt, and you must find him not guilty, because your doubt is reasonable. A reasonable doubt as to the guilt of Matthew Terry may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. I submit to you, we have a lack of evidence here. We have conflicts in the evidence. We have doubt that arises from the evidence itself, as I'm going to go through in just a moment. But I would remind you of the very last part of that instruction.
Inferred.
Which
Inferred is the
is-
word.
If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should find him not guilty of first-degree murder. That goes back to the very first thing we talked about. But also in regard to any crime at all, if you have a reasonable doubt, you do not have a conviction of his guilt, an abiding conviction that doesn't waver or vacillate, you have to find him not guilty. Remember those instructions as we're talking about what actually occurred. We started first with the thing we know, really the only thing we know from their theory, which is that at 11:56 p.m., there's a text that everything's all good now. So we know that.
Saul Goodman.
We know they got home. We know everything was fine. We also know that they're getting ready for bed. How do we know that? Kay's shoes are off. Matt's shoes are off. Matt's keys are by the bed. All evidence. We also know that there's something that occurs where that screen is gently, quietly placed against the house.
Certainly not
I
escaping
submit to
from
you
a murderous
reasonable
husband.
inference is that prior to them getting home, that screen was
Strap
gently,
on, people.
quietly placed against the house. and someone entered their home, knocking that stuffed animal out as he got in there. He's in the house, they come home. What's somebody who's entering, I'm just going to call him a burglar, it'll be easier. What's somebody who is a burglar in a home going to do if the occupants come back? He's going to get the heck out of there, right? So he hears them coming in. Where's he going to go? Is he going to go out the front door or to the garage where they may be? No. He's going to go exactly back the way he came, where he knows he can get out, because he had left the window open when he gently placed that screen against it. What's he going to do to buy himself a little time? Lock that door. That's why that door isn't kicked in, because they had no idea he was in there when they came in the house, took off their shoes. And when Matt went into the bedroom and put his keys down and took off his shorts to get ready for bed, Kay went out that front door. Remember, the front door was ajar. She heard a noise. What she heard was him getting out of that window again. Remember, he would have come in back to the room where he had come in to go out the way he came in, because that's the way he knew he could, which is why the screen is gently placed against the house. And as he's in there, locking the door to buy him a little bit more time, Kay hears the noise as he's crawling out the window, goes out in her bare feet to see what the noise is. And as she comes around, she's attacked. And that's why her blood is all over the front there. Remember, Kay's blood is right here. There is no evidence that the other blood is hers. If you look at the key at the bottom that Anna Cox told you was correct, the yellow is Kay Baker's blood, the orange is where Kay Baker and Matthew Terry's blood got mixed. So the only place we know Kay Baker's blood is right here. And if Matt, as Anna Cox said could have occurred, got Kay's blood on him here trying to help her, which we'll get to in just a moment, and then got attacked, he could have easily gotten her blood here and here as he's stumbling to get away. No yellow here, because they didn't bother to test it. None of that blood is Kay Baker's. So as Matthew Terry was in the bedroom putting his keys on that nightstand that you actually got to see the photograph of, remember his keys were right there. He's in his underwear. He hears Kay get attacked and immediately goes out to help her. He finds her laying there, right where she's found. Bends down, gets her blood on his hands, sees the woman he loves dying, and is attacked himself. And that's how the blood ends up here. He's stumbling to try to get himself back to a point where he can see what on earth is going on, and he hits the fence there. And that's how the blood gets there too. He's able to shake it off and then chases the assailant. He's bleeding already. Remember, you can tell from the photographs, you saw blood in his nose, blood on his face, there's blood all over him. He is actively bleeding. And that's why there's some of this blood that is his. You can see the blue is his, the A and the J there, Matthew Terry's blood. But some of that pink is not his, because he goes after the assailant. He goes after the guy who tried to end Kay Baker's life, and ultimately, Matthew finds out later, did end Kay Baker's life. But Matthew doesn't know that in those moments. He's going after the person to stop him from getting away.
And leaves his wife bleeding to
And
death
there's a
next to the
struggle,
house.
Which is why there is all that blood. Now, when we're here, you can see there's crossing over. Matt gets here. Matt's bleeding here. And the assailant is able to get further down. Now, he's still chasing him, trying to keep up with them. There's a question mark here about whether there's more blood here, because
And his
again,
beloved
they didn't
wife
bother
continues to bleed
to
out
get that
here.
evidence. They didn't bother to take photos there. They didn't bother to document that. But as Anna Cox testified to, there's possibly even more blood along that area here before we get to over here. And I submit to you that area where Anna Cox testified, there is a large pool of blood, is where Matthew is more sufficiently and more vigorously attacked with the other stab wound to his neck. Now remember, Matthew had one stab wound here, one stab wound here, blood in his nose, blood all over his face, blood all over his clothes. So all of this is not just Matthew's blood.
Cool story,
but
bro.
it's also the burglars. And some of this back here, I submit to you, there is more blood there that they just didn't bother with. The police just didn't care. They thought they had their man. And over here, they ignored the fact that Matthew was further and more seriously attacked there and didn't even bother to test that blood. Matthew was attacked where Deputy Hall found him almost dying, pale,
Almost dying?
lethargic, as he described. And that's why Matthew was still there. Think about their theory. They want you to believe that he just laid there for 5 hours. That's absurd if he were the killer. He would have got up, got to those keys, got to the car. Why would he stab himself over here and then stay on the scene? He had at least 15 minutes where he could have just gone towards Lithia Pinecrest, crossed back over here, got into his car and got out of there. Remember, Jonathan Figgins and Ruth Figgins didn't know who Kay Baker was at the time. They thought it was some teenager. They didn't know it was her. They would have thought nothing of somebody a house over just leaving their driveway, leaving their garage. He didn't do that because he was attacked. He couldn't do it. He was laying here injured, almost dying, as Deputy Hall indicated.
Almost dying for 5 hours.
You heard the weakness, the quietness in Matthew's voice.
Was it
Slurred
really
speech.
5 hours?
He was
5
stabbed.
hours to discover him in
They
the
want to
bushes?
say, oh, he was
Yeah.
just laying there. He couldn't call out. You heard the weakness there. He was so injured, he wasn't even sure he could get up. He had to be helped up, assisted by the deputies, walked out, medical treatment, and ultimately surgery. Remember, it's not my job to tell you what happened. It's theirs, and they didn't do it. They have to prove their case beyond and to the exclusion of every reasonable doubt. They've given you a theory, a bunch of assumptions, and zero evidence. 31 witnesses, each one we went through. Not one points to Matthew Garrett. Their burden
I'd be a
is
bad
to
juror.
protect us all.
Oh, what happened?
Oh,
Matthew
She's-
Terry is innocent.
she's bringing it home. Ooh, that's
They didn't
bad.
do this.
No. I don't know.
A thing. And as hard as it is, the law demands that you go back there and vote not guilty.
That's the close.
Thank you.
All right, so we're gonna have a state rebuttal here. Now the state has to be careful because there's a lot of targets and they need to be methodical and cool. The thing is, a rebuttal arguments where they always get in trouble because they get angry at the defense and they think they want to they get exasperated. You cannot ridicule the defense, and you can't burden shift. Now, I don't like the way that she burden shifted to herself.
Yeah,
She
so
says
you think she crossed that line with, let me show you how it really happened twice.
Yeah,
And
I don't like that at all because people are talking Chewbacca defense. You don't do that with Chewbacca defense. You don't give them a theory by which you can be ridiculed. You create confusion and doubt in the state's case. Now, I understand she's trying to create an alternative theory that she thinks the state hasn't disproven, but that is not the Chewbacca defense. All right.
yeah, but when you say this is what happened. This did this. The guy took it very carefully and put it at an angle so he has to climb over the screen. He goes in, goes, oh my God, they're coming home. I better lock the door, climb back out, wait around, stab him, stab her, wait for him to come out, stab him, run off. Oh my gosh, I'm being chased by the guy. When you start doing that, instead of saying it's possible there could have been another attacker,
Right.
There's nothing to exclude the possibility someone was in the house waiting for them. It was so pointless that she did that.
Well, she's in a tough position because this is a strong state case, right? And her client has some input in what the defense is. Now, ultimately, it's the attorney's call, all right? But you cannot concede elements of a crime if your client does not consent. It's very important to know this, okay? So if she wants to go for second-degree murder, people say, somebody asked you, how would I defend it? I would definitely be going for second degree or heat of passion, right? Because I think this is a heat of passion killing and it's not a death penalty. And if you get heat of passion, it's not subject to the death penalty, so you win. But in order to do that, you need permission from your client to concede that element. All right. So if she does not have permission to see it, then this is really her only thing that's left, is to argue reasonable doubt on the evidence and maybe alternative theories, which the state hasn't accommodated. The problem with that, though, well, I think, first of all, she went too far. I think she brought in, when she said he's innocent, you never have to prove innocence. Mm-hmm. Now, she's saying it, and there's a fine line here. And sometimes you got to go all the way, right? And she's bought into her defense case. She's got the defense hat on, so she's going to believe what she's saying. One thing I really like about this defense attorney, too, is that she's got a consistent demeanor throughout. A lot of times you'll see, like, especially women attorneys, but I've seen men attorneys do it, too, is they'll put on a mask. And when they're talking with something friendly, they're like happy. And when they're talking with somebody they don't like, they're like condemning, yeah. And whereas she's always the same kind of go-getter at all times, right? Charge straight ahead. So that's good because it shows credibility. And I think that she does have conviction behind what she's saying. So let's assume that the client does not give her permission to concede the homicide, any kind of identity issue. She's got to go with, there was some kind of reasonable doubt here. And, there was some third person attacker. When she fleshed that out, I don't know if I would have gone that far. It's a tactical choice for the defense attorney. It's stylistic. Whether she's bringing on a burden of proof onto herself, that will be an issue for on appeal. Probably they were or post conviction, that in post conviction saying ineffective assistance of counsel because she shifted the burden to herself and that was improper. So I think they're creating a post conviction motion by this burden shift back to the defense. I don't know. I mean, it's easy to sit here and criticize, but she's in a tough position, right?
Yeah.
So I like her. I think she's excellent. I think this defense team is excellent. I would also say, if they come back guilty here, she should not be on penalty phase, because if they disbelieve her on this, which I suspect they will, for her to come back and say, oh, well, okay, so you all decided he did it. Well, let me tell you all this other stuff which should mitigate. Now you kind of lost credibility with the jury. You want to have a different face. And there's a team back there. You see, I've seen at least 2 other attorneys. So those are probably penalty phase attorneys that are going to switch chairs.
Well, I mean, it's that whole, burden shifting thing that is so pointless. Like I said, instead of just saying it's possible, they didn't rule this out. This could have happened. They didn't examine this in detail. Now she's gone and said, this is my story. And it's a ridiculous story by any stretch of the imagination. And you were seeing in chat, random people that aren't lawyers going, this is the stupidest thing. And immediately goes from, okay, she's not casting doubt. She's just sounding stupid. And that she's clearly wrong. And so therefore, I have to go for...
But okay, the guy's entitled to a defense. You're a public defender. You have to defend him. He doesn't want to concede guilt. He doesn't want to concede identity. So you can't go for second degree. So you have to say he didn't do it. Or the state didn't prove beyond a reasonable doubt that he did it. Well, there's a lot of evidence here to overcome. So, I think that she's done as good a job as you can possibly do if that's the situation. If they're choosing to do this, this is not the strategy I would choose. I would choose to go, I would use the penalty, I would use the guilt phase as an enhancement for my penalty phase, I would say I'd go for my second degree heat of passion, which I think this fits. I think this is a heat of passion killing. And then if you lose that, you go to penalty phase, really hammered home. Okay, I understand you found him guilty of first degree, but this isn't CCP, cold, calculated, premeditated. This isn't the kind of case that deserves the first degree murder because of this heat of passion and drunkenness element. So, but this again, her hands may be tied on that issue.
Well, that's it's not the best situation to be in for the defense counsel, because I'm getting I'll tell you how to handle my defense vibes from him. He seems to be
he's a control guy. Yeah.
So let's burn through a couple super chats and a few other comments, and then we'll get on with the state's rebuttal, which is quite interesting as well.
Always my favorite. When I'm doing appeals, I love, because this is where the state can screw up, and they've been very clean. So I'm impressed with the state on this one. Don't screw it up for me. I want to have a happy feeling about my prosecutors.
And after we finish with the state's rebuttal, we'll go straight into the verdict and we'll call it a night, because the Brooks actual real sentencing is happening at 1 p.m. Eastern time. So 2.5 hours from now. And I want to get a couple hours sleep before that happens. Where are we here? Sonia Chris says, I bet she'd say there's no evidence that the earth is round either. Well, if that's what you got, that's what you got. And especially if they pay you to say it, but she's
look out the window. Look out the window. Do you see any curvature?
Yeah. You and who's Army? I'm joining this late. Is there an aspect of this case that is a twist or odd / interesting? The news articles I see online makes it sound open and shut. This is a very, very straightforward case.
But this is a great trial to watch, because
I think it's interesting in its lack of twists or odd things.
Well, also that you have competency all the way around. I mean, you're seeing really competent lawyers, a good judge, and it's done clean. And with so many of these media cases, there's some weird issue, and so watching a case like this, you can learn a lot. You can learn a lot because you're seeing great attorneys at work, and I salute them all. Of course, I reserve judgment until the state finishes its second rebuttal closing.
And Vince Clortho says she was trying to get out quietly.
No, she wasn't. She was going all out, man.
Sonia Chris again. This makes Brooks look rational.
No,
it's not the best story. Again, I think some sort of mock trial would have helped to at least run that story past a few people that aren't knee deep in this.
No, I guarantee you they did mock trials on this. We just had a death case here in Putnam County, and I was on the jury selection panel, or I did the mock trials. I didn't actually do the jury selection on that one, but we ran 2.5 months of mock trials. Every Friday we would have mock trials. So that was probably
scary that somebody couldn't think of a better story than that.
Well, but what you do is you question your mock jurors, and you show them, like, okay, here's what we do. And they say, well, we really want to hear from the defendant, right? But he can't testify because he'll get crucified, right?
Yeah.
So that it's like, well, what if we told you this is his story, right? I mean, a lot of this is tested by mock juries, and sometimes there's no good answers. Sometimes you do the best you can and with what you got.
AP says, well, since he has prior knowledge of women being stabbed, he knew there was nothing left to do. Ms. Baker just chased after the phantom attacker. Yeah. Sorry, wife, I love you, and I was just caressing your dying body, but I'm going to go after this guy. You just sit here and bleed to death. Whatevs. Hugh, pause, Jas. Was it always called the Chewbacca defense, or did South Park come up with the concept? South Park came up with the concept.
No. Wait, that's not right. No. Well, the Chewbacca defense is definitely South Park, but but we've had this for a long time. It's called the chaos theory.
Yeah.
And there's an alt, because I'm not that way. I go right for them. This is the issue in the case, and this is the thing, right? But there are other defense attorneys, which what they do is they cast doubt on everything maximally. Okay, and if you do that, what you're doing is you're playing into every individual juror's reasonable doubt. So they create their own scenarios in their heads, and you play into that to create confusion in the jury so that they say, well, I have a doubt. See, by explaining away, this is the problem with her scenario. By creating this alternative scenario that she is positing, now she's creating a target, and you are resolving. So the defense says this is what happened. Well, that's not what I thought. I thought the doubt was over here. Now your doubting juror becomes a certain juror because it's like, you aren't even telling me the doubt that I had. Whereas if you question everything and then leave it to the jury, they all may have doubts like, well, I don't know, that evidence bothered me, and it's unresolved, it's reasonable doubt, you see. So that's what I always call the chaos theory. The Chewbacca defense is a funny take from South Park that came later. I only learned about that about 6 months ago, but I've been doing chaos theory for years.
Yeah. And I was just meaning the term Chewbacca defense.
Yes, that's definitely South Park creativity.
All right. That's okay. That's all the super chats we have up to date. Now just a couple of comments that I thought were interesting. Legal Vices, I just got here. Convince me he's guilty. What evidence convinced you so sure? I'm not being facetious when I say all of it. Well, taken as a whole.
Well, go through it. Go through it's not much. I mean, you have all of the witnesses at the table, the drunken party, his intent, his like he's angry because he's jealous. And the
jealousy is evidenced by him following her to the bathroom, following her from the bathroom, following her to the other table, following her back to their table.
So we have a motive, which is not always happen in a murder case, right? So you have motive, then you have him, and then you have the evidence of the smashed in door, the flight out the back window, where the woman flies out the back window, a pursuit where he goes in. Now there's a blood trail, so she's stabbed. There's a blood trail. There's blood. Oh, his DNA under her fingertips. On his hands is her blood. On a fleeing fence post, there is a handprint with a mixture of her blood and his blood. Right? There is evidence of flight where he flees from the situation, is drunk, and found drunk where he in suicidal stab wounds in the neck, where he's trying to go for his neck, but he fails. So, and he is drunk. And we have the Williams rule witness of the woman who was stabbed in a drunken rage in a very similar kitchen knife situation.
In the same area of the body.
In the same area of the body, almost murdered in Williams rule evidence. So similar type design. He's a violent drunk and likes to go stabby on his girlfriends, right? What am I missing? I mean, there's a lot of...
Yeah, that's what I say. I wasn't being facetious when I said literally all of the evidence. It's 99% circumstantial, but there's so much of it, and it lays such a linear view of the case.
The bloody handprint on the thing with the mixture, I think is the worst evidence for him in the whole case. Aside from all the circumstances, I mean, because how do you explain that? Yeah, very hard.
Illegal Vices says, oh, that was one we just read.
He tried to suicide himself by stabbing his own neck with I am curious what happened to the knife, but they can get tossed, and it's hard to find that stuff. But
well, and that's a question that's coming up here in just a second. I haven't followed this case, but this defense lawyer comes across extremely smug. I deeply dislike her after 5 minutes without even knowing if what she's saying is true. That's something you don't want to have your jury saying,
Yeah, I don't. That's hard because likable. I don't care if you like me as long as you get my client not guilty.
The Bee's Knees Gaming, the missing knife isn't some great mystery. It clearly wasn't made of a material that a metal detector could find, or it was in a tree. That's the thing. If it was a ceramic knife, the metal detectors wouldn't pick it up.
Oh, that's interesting.
That's something I hadn't thought about until I read this comment. That's why I highlighted it. I hadn't thought about a ceramic knife or something, or a clay knife, something like that. Given I have reasonable doubts of the defense, and see, this is this whole burden shifting thing. To now, it's like, okay, they lay out their case, and now people are saying, well, I have doubts about her version of the story.
Yeah, see, that's why it undercuts your chaos theory, because you're not letting the jury come up with their own individual doubts. You're resolving those doubts by laying out a story that you're saying happened, which they're going to think, oh, that came from the defendant. Well, maybe their doubt had something else to do, right? And isn't consistent with what you're telling them. Now you've resolved your doubts. So if you're going to do that, don't lay out that alternative. I mean, I understand that you feel the need to do it. These are hard calls. I mean, how do you defend this, right?
And Hugh, pause, space, Jazz. Did any of this come up during the trial? No, these are arguments. This is I mean, would it be too facetious to say that the defense can literally say anything they want, essentially, during the closing arguments?
Well, that's a good question too. You make a lot of good questions, Vices. Where do you come? Are you a lawyer or something? No, I think they can. I mean, my philosophy is you're on trial for your life or your death, right? And I think that the defense should be able to say anything. The defendant should be able to say anything because it is their
including jury nullification.
Well, that's an argument.
See that I was going to say that. That's
Yeah.
what we asked. That was people asked yesterday. Well, can she bring up jury nullification? I'm going. Any lawyer, if you ask them that, they would look at you like, no, God, I'm not even going to think about possibly saying that because the lawyer would get crushed instantly.
Well, that's another debate about whether you have to follow the law as a defense attorney or officer of the court and to argue. Now I could see a case where I would argue that and say that I should be able to, and I want to set up an appeal to overturn the line of cases which says that I can't argue jury nullification. All right, but really the way to do that would be to argue that and then get it denied by the court. Then the court would have ruled it against it, and then it's preserved for appeal. So you could do that without doing it. I don't know, where are we going? I'm off track.
No, I was just saying. It's essentially her closing arguments don't have to be based on anything that the prosecution put up. She can just say anything she needs to do to cast doubt in the minds of the jurors, essentially.
Pretty much. I mean,
there's limits, but it's a broad,
very broad, and it should be because her client's the one that's facing the chair, right, or the injector and the needle.
Spooky Spoon. When is Brooks' trial starting today? Please, Jeff. In an hour, 2 hours and 15 minutes is when it's starting. We got just a couple more super chat. We got one here, a comment from Nathan C., member for 3 months of the Clean and Sober crew. Thank you so much. The best part of waking up is legal vices in your cup. Steve, it's self-delete, not the word that starts with an S and ends with "I'd." We're after the 2 hour. We're past the 2 hour mark. We can pretty much say anything at this point. And don't say anything, chat, because I know what words you're going to start slinging around. I mean, we can say words like suicide. Other things are still a big no.
Really? Tell me I don't understand any of what you're talking about.
No, it's like YouTube really hates the word suicide, and they tend to flag things and delete things. But after about 2 hours, they just don't really care anymore. So it's pretty much open season after 2 hours. But it's like the real vulgar stuff.
But that was in the medical report what he was being treated. Yeah. That they were treating.
Yeah. YouTube doesn't care. They just they just gave a strike against Joe Neerman. Good logic. One of the Jewish people on LawTube for breaking down Dave Chappelle's Saturday Night Live show and giving his Jewish comments on whether or not the jokes were anti-Semitic. They gave him an abusive language copyright strike for that.
We can't have people talking about things. That would be terrible.
Especially not Jews talking about anti-Semitic jokes.
Yes.
How
dare
they?
That?
Yeah. Police recruits in California injured. Driver went Brooks, says Fiery Red Podcast. I haven't seen the news.
No, so I don't watch much news. I try to avoid it.
It's just depressing.
Yeah.
So that's where we are. We've got one more super chat that just now popped up. Then we'll get on with the rebuttal and bring up the verdict, and we will be done. And then we'll talk about where we go from here after we wrap that up. A Kingslayer Damocles is the only thing Daryl Brooks has for appeal. King Damocles is? Okay. Something is the only thing he has for appeal. The fact that the judge made a ruling only the state is allowed to lead on cross.
No, she didn't rule that way.
No.
The parties are allowed to lead on cross.
Yeah.
And Brooks.
That was just
stupid.
Brooks. Yeah. That was literally exactly what I was going to say.
He doesn't understand, and he thinks he's being treated unfairly, but he never.
Yeah.
They never called him. The state never objected to any leading question that he had. So it was never an issue because the state knows that he can lead, right? So he thinks, wait a second, they're leading. And so he calls him out. He says, no, the state can lead on cross. Well, so can he. And he never got called on it, right? Because the state knows what they're doing. He's an idiot. Yeah.
That's literally, you can't lead on direct, but you're supposed to ask leading questions on cross-examination.
And you can. In fact, this is another thing that annoys me. You lead. I mean, I'm not a big fan of this anti-leading thing. Most preliminary stuff you want to lead on. It's the important stuff that you go to the passive questions. Well, tell the jury what happened after when you arrived at the bar. All the preliminary stuff, you can lead to get it going, get it to the point, and then get with the witness telling them what they saw. So even if it's leading on direct, it's not objectionable if it's just preliminaries.
Yeah, and you know, I mean that's it. Do you want to be an idiot and object and make them take 3 minutes to ask a 2-second question, and you're going to get exactly the same answer on something that doesn't mean anything? But yeah, this was just Brooks being a complete idiot.
He's an idiot. He doesn't know. Yeah, everything's, he's being put upon. He's being treated and so he was treated so fairly that it makes me sick.
Yeah, exactly. And Nathan C., for phase 2, since it's 2 hours away, will you do 1.5? We'll talk in a bit. We're not.
How long is the rebuttal? Do you know?
The rebuttal is just a few minutes.
Okay, let's do it, man.
Yep. So yeah, we'll do the. We will do the rebuttal. There we go. We'll talk in a minute here, Nathan C., about that because no spoilers. All right, here we go. Let's bring this up. Get back in with it. And while I'm out here, make sure you go to crimelaw.net and order this fantastic book written here by Stephen N. Gosney with foreword by Andrew Branca, Law of Self-Defense, and a blurb and a mention from our very own Nick Rekieta.
Well, actually, can I make another plug on this?
And another plug.
Well, I've actually, because people have been so generous.
Excuse me, it fell on the floor and the dog is looking at it like, new toy.
This book has actually been, this is actually into the 2nd edition now. I have added a chapter on closing arguments and proper closing arguments and improper closing arguments from the part of Florida prosecutors, as well as the way a prosecutor should present their case, which is very relevant to this trial and what we're watching right now. I'm going to email that article to everybody who bought the book, but anybody that buys the new book now will get the 2nd edition, which includes an additional chapter. And I've upgraded not only the cover, but the paper and the page. I've spent, because this is a vanity project for me. I mean, kidding, I'm not really making a lot of money, so I figured I would give the best quality book, because the original is like, I'm going to lose a lot of money on this, but I've made a little money, which is like $800, $1,000 on it. So it's great. So I said, I'll pour it back into the book to give you the best quality. It's going to have a beautiful diamond printed front cover. I've rearranged the cover to make it a little prettier. I've added a chapter. I've upgraded the paper and the pages. So if you want to order it, it's a pre-order on the 2nd edition, which I should get next week. And you will get the best version you will ever see. It's going to be really a good quality book with great content, a lifetime of my poured into this book. And I'm really proud of what I did here. So please do purchase it at crimelaw.net.
And Alan says, I've been asking how you can get a book to Australia.
Okay.
If you go to his website there, crimelaw.net, and go to the About section, it'll have his email address. You can email him there, and he'll give you the deets on how to do that.
Well, I just sent one to Ireland, and I'm sorry to say it's expensive to ship. So what I did was I said, buy the book and then donate me the difference for the shipping, and I'll make sure you get it. Now, to Ireland, it was an extra $25. So send me your address. We'll get you the shipping. And if you buy it and give me an extra donation that covers the shipping, I'll make sure you get the shipping. And that'll just take a little dialogue. Just email me. The email's at crimelaw.net.
And in the last 20 seconds before we start again, I just want to say, hey, make sure you go and hit the like button while we're talking here. We got 1,400, we've got almost 1,500 people here and 850 likes. So we can double that, because I'm sure old people have dropped off, new people have come. Please do me the favor of getting down and hitting that like button, because that's what YouTube looks for. They look for the likes. They look for that engagement in saying, oh, lots of people like this, so let's recommend it to other viewers. Let's recommend the channel. So I would be deeply, deeply indebted to you and grateful to the end of my days if you would just reach down there and hit that subscribe button, hit the like button. We have some memberships you can join if you want to. But the like and the subscribe. And the subscription, we started out today at, 32,300 exactly. And currently we are at 321. We've had 20 new subscribers since we started. 21 new subscribers. So, hey, thank you very, very much. Aussie Overlord received his book, apparently. So he's been pimping you on that one too. That's cool.
Okay, yeah. I sent one. It's Australia. Yep. That was a freebie. You know, a lot of, like I said, you make the numbers. You're like, you made more than 1,000. Yeah, but I've given away a lot of books. and I do that because I want the information. I want you to read it. It's the content. It's not frivolous. This is a lot of work. I mean, what do you think? Did you read any of it? I mean, it's like, it's not frivolous writing.
Yeah. And it's very informative. It's deep, but very, very approachable.
Thank
You don't have to be a lawyer to understand it. And it's very well written. And Spooky Spook says, are we going to do Brooks now? We're going to finish this up. And then Ricada is doing Brooks, and there's no way I'm streaming against him. I'll be crushed.
This is a great trial. This is a great trial to stream. So good job, Vices.
I had no idea. It was just something that was going live, and I wasn't doing anything live. So I took a gamble, and this is what we got. So again, like, subscribe. Oh, we got 959 likes now. That was really quick. Thank you so much, everybody. Just 40 more people. Get up there and let's get us up over to 1,000 just real quick. All right, we're going back in here with the defense, with the prosecution's rebuttal. Let me fast forward it here. No, he stands up pretty quick, so we can just play through.
Does anyone need a break before the rebuttal?
That's the wrong one. There we go.
Absolutely.
Thank you for getting us over 1,000 likes. You guys rock. That is so cool. Thank you so much.
Okay. You heard it. Miss Perry told you what happened. It's not evidence, but she told you what happened. Matthew Terry is the brave hero who chased down the assailant who murdered his girlfriend.
I love this.
In an attempt to apprehend him. That's what she told you. She didn't have to tell you the story. She said she would do it anyways, and she did. Okay.
Okay.
So, Kay Baker and Matthew Terry are in fact the last two people together. He's the last person with her, right? They're home alone, right? They got home. They started to get undressed. Everything was going normal, right? That's what they said. And some man decided to break into their home. Homes do get broken into. He doesn't break a window. He pulls the screen off. The window to a child's bedroom that a mother has left unlocked is left unlocked so it can be opened. He kindly takes the time to raise the blinds, because the blinds are raised, right? They're not pulled down. They're not crawled through. He takes the time to reach inside and raise the blinds, and then he crawls in through the window. And now he's discovered that there's people home. So he decides he's going to get out of there, and he's going to take the time to lock the door first before he climbs back out the window. That's the story, right? He doesn't put the blinds back down to conceal his retreat. He doesn't close the window. He doesn't put the screen back. He just crawls out the window and he walks away. And Kay Baker, and only Kay Baker, hears this noise. And what a woman does in the middle of the night with a man in the house, she says, I'm going to go wander outside alone.
I love that.
Figure out what the noise is that I hear inside my house. That's what happens, right? She has to wander outside. That's clear. She's got to get outside the house. She doesn't die inside the house. She's got to wander outside alone with a man in the house. She doesn't say, honey, I think I heard a noise. Could you go check?
Base. Good there.
And not to be chauvinistic, women are certainly capable of checking for themselves. She doesn't go room to check, right? She just immediately walks outside barefooted. Doesn't take her phone, doesn't use it as a flashlight, doesn't bring it so she can call for help if there's a problem. She fully exits her home, as depicted here in State 64B, which she exits over here on the left side, the side away from 6209. And though she's heard a noise inside her house, she walks all the way past the front of her home, through her driveway. She walks across the yard between her home and 6209. She crosses past 6209 for no appreciable reason, and there she is set upon by the burglar, who is still hanging out waiting to murder her.
Ouch.
Right? The guy who
this is why you don't do a positive theory.
6209, so a woman who's coming walking through the driveway in the open public space He's just waiting. And now he's not a burglar. He's a cold-blooded killer. That's what has to happen. Right? There's no suggestion in the story that Miss Perry told you that Kay Baker chased him out of the home. She was running after him to try and stop him. She fully described the notion that the guy got out the window, fully got away, and Kay Baker decided to wander outside alone, doesn't bring her boyfriend, doesn't call the cops, doesn't bring a flashlight, doesn't bring any weapon to defend herself. She wanders out into the night to look for what is a suspicious noise. And she gets murdered. She gets murdered in a most intentional and a most premeditated fashion by the Phantom Killer. And somehow, Matthew Terry, who's just chilling inside the home in his underwear, hears a noise and decides to wander all the way out from the bedroom, which is in the back left corner of the home, all the way to the front of the home, all the way outside, all the way past the front of 6207, through the yard heading into 6209, past the yard of 6209, and somehow he knows that his girlfriend is laying dead on the ground of 6209. And by the way, the cold-blooded killer is still just hanging out.
Ouch. Oh my gosh.
He's just waiting. He has to be.
This is tough.
Right? Because there has to be enough time that Matthew Terry can walk up to the scene, see his girlfriend laying dead on the ground.
I love his laughter,
and make
too.
the conscious decision to get on the ground and render her aid, because he wouldn't have to know that the cold-blooded killer is standing right there, knife in hand, ready to murder him. Right? So the cold-blooded killer has now lain in wait a second time for a reason that he doesn't have to think that another person is going to come along, so he can kill a second person in what started in a home burglary. And now he attacks Matthew Terry, right? Because Matthew Terry's got to end up with Kay Baker's blood on his hands. And what the defense has told you is, that's Kay Baker's blood on his hands. Right? That's what they said. Matthew Terry gets the blood on his hands because he's rendering aid to his girlfriend, because he's the good boyfriend. And now he's being knife attacked. And even though Jonathan Figgins told you that he heard the sound of a female voice, right? Which has to be Kay Baker, because Matthew Terry isn't a female. And I guess you could conclude that the person who was wincing in pain as if they were being injured was the Phantom Killer, but that seems a stretch. Jonathan Figgins hears no noise of a second fight. There's no yelling, there's no screaming, there's no calling for help, there's no anguished noise coming from the mouth of Matthew Terry as a knife is now being plunged into his neck.
Twice.
Not a fatal wound. Nowhere near the level of the extent of injury that's done to Kay Baker. And according to the defense, it's just a one. He stabs him one time in the neck because they still got to leave room for the second neck wound that's going to happen later. Right? Now Matthew Terry has been stabbed in the neck and he is stumbling through the yard. Right? Conveniently depositing his blood and Kay Baker's blood all over the place. And for no appreciable reason, he runs up along the fence line. He's not putting his hand on the fence as if he's supporting himself because he's so weakened and so beat up. He goes all the way down the fence line and doesn't touch the fence with his hand until he gets to the north facing. The facing Lithia Pine Crest. That's where his handprint is. It's on the north facing. It's not where Z and Y and X and W and V, it's none of those. Right? So now the cold-blooded killer is watching Matthew Terry stumble helplessly along a fence line and doing nothing. He's not going to finish this guy off, right? There's no second attack. There's no wound to the back of Matthew Terry. There's nothing. He stabs him once and then watches the guy wander off. And then, if Matthew Terry goes north along the fence line, the killer doesn't run south. He doesn't run east through the front of 6209 or west past the front of 6211. He doesn't run anywhere opposite the man that he's just tried to kill. He decides to run through the backyard of 6209 and 6207, and somehow, even though 30 seconds ago, Matthew Terry was stumbling weakly and helplessly through the backyard. Now he finds the strength of conviction to chase him through the yard. That's what you have to believe.
That's careful
the
there.
moral fortitude to
Objection,
chase this
verdict
man
shift.
down. He doesn't say,
But see, the defense
I
set
should
it up.
probably go help Kay Baker, who's not dead yet. Because when Jonathan Figgins finds her, she's not dead yet. The killer has left the area where Kay Baker is. He's running northwest through the yards, and Matthew Terry doesn't say, go save Kay. Go help Kay. Go scream and yell and call for help. Go bang on the door of a neighbor's house. Nothing. He's now just going to chase this man who's armed, who's already supposedly nearly killed him once with a knife, through the darkness and through the bushes, down the dark side of Lithia Pinecrest. Which has to ignore the complete fact that the blood pattern here shows somebody was lingering, hanging out. It's not the phantom killer. No one stabbed him with a knife. No one's beaten him up. The person who's bleeding is him. It's the defendant. He's got to be lingering. Why is he lingering? That's what the blood pattern shows. The person's lingering in the corner. And now the killer goes through the bushes, and Matthew Terry, girlfriend still on the ground, still dying, still bleeding to death. Every heartbeat that she has is killing her. Says, I'm going to keep chasing this guy through the bushes. I'm going to go further into the darkness. I'm going to go further away from people. I'm going to go further away from help. I'm going to go further away from any person who can do anything to make the situation any better. I'm going to keep chasing the guy with the knife. And he runs all the way down the road, a football field, chasing this guy. Just a bit ago, he was weakly stumbling along a fence line, but now he's got the strength to chase him down a football field. And then we get to here. State 64A. The killer has run away from Matthew Terry. Matthew Terry has chased him this whole distance. And now the killer decides to turn and do a second round of attack on Matthew Terry. And miraculously inflicts an almost symmetrical wound on the other side of the defendant's neck.
I love the sarcastic laugh he
just
does
a
when he's
killer.
explaining
He's
this.
deadly accurate,
I know, this is good.
right?
I
Matthew
must
Terry
say.
has no other wound.
And I think it's
There's
been
no
pretty fair.
wounds to his hands. The doctors don't have to repair wounds to
I'm
his
looking
hands,
for objections.
Right? Defensive wounds. You know who's got defensive wounds? Kay Baker. You know why? Because Kay Baker was attacked with a knife. That's where the defensive wounds are. You saw them. Matthew Terry's got no defensive wounds on his hands. He's got no stab to his abdomen, no stab to his face, no stabs to his arm. This phantom killer stabs Matthew Terry once over by Kay Baker, and then miraculously hits the exact opposite side in an almost mirror identical situation over here. And now Mr. Terry is bleeding all over the place. Even though Anna Cox tells you that there's lots of bleeding that's occurring and it's spattering everywhere, blood is spilling from Matthew Terry everywhere, right? And the killer decides to walk away. He doesn't finish off the eyewitness. He doesn't finish off the person who the killer could reasonably conclude would say, yeah, I saw the killer, this is what he looked like, he was 6 feet tall, he was whatever. Right? He doesn't finish that guy off. He stabs him a second time and then he leaves him. That's what you have to believe. He leaves him. And Matthew Terry is what? Now he is conveniently weak again. Now he is conveniently too weak to walk because he's being attacked, according to the defense, at the back of 6221. Here's State's Exhibit 3A. There's 6221. Right? Matthew Terry has got home after home after home, and even if you say, well, he's stuck in the backyards and there's nowhere that he could go because the backyards are fenced, he's got to go exactly 3 houses and he's at the end of the cul-de-sac, right? He's back on the street. Remember how the defense has gone to such great pains to tell you all how accessible this neighborhood is, how easy it is to take the walking trails, how easy it is to just walk down the cul-de-sac, how easy it is for a person to get in and out. But Matthew Terry, who's now been attacked twice, hasn't the foggiest clue what's happening with his girlfriend, who's bleeding to death in a neighbor's yard. He lays down on the ground. Right? He has no strength left now to do anything. To scream.
That's what I heard
to yell,
too. Cul-de-sac.
To bang on a fence with a stick. To walk. Just walk. Walk a few houses down and get access to the cul-de-sac and find any person. Any person. None of that happens. None of that happens. There is nothing reasonable about that. You can play that game all day long, and you will exactly do what is possible, what is speculative, what is imaginary, and what is forced. That is exactly what you would do. The defense tells you that there is no indication
Brilliant.
that the
This is
doors
great.
of those homes were broken that night between Matthew Terry and Kay Baker. And I challenge you to go look at all the photos, because the state of Florida put photos in of every room of that home. A home that is filled with 2 children. Kay Baker was the mother of 2 children. And go look and see how clean that home is for a mom of 2. Go look and see how lovingly, how carefully all the dishes are arranged in the dishwasher. Look at the photo of the closet, how all the clothes are hung. Look at the photos of the kids' rooms and how relatively neat they are. I mean, you can guess the relative age of these kids. They've got stuffed animals. They've got a Hot Wheels track, right? And look at the things on the ground. Look in the master bedroom and look at the strike plate and the piece of the lock that are sitting on the ground directly in the area Matthew Terry had to have walked that night when he got home and went to put his keys on the nightstand. If that door has been cracked for days, if some apathetic landlord didn't bother to clean up the mess, it would have had to have been sitting there for days. Nobody picked it up. Nobody did anything about it. Go look at the hallway outside the children's bathroom. Go look at the kid's bedroom that doesn't have the open window and look right at the entrance, and you'll see the strike plate on the ground from the bathroom. And right next to it, you'll see
Grounds.
the toothbrush still in its packaging, the plastic wrapper. That's been sitting there for a long time, and some kid never picked it up, never moved it. It just conveniently got left there all that time. There is nothing reasonable about any of that. Nothing. Matthew Terry killed Kay Baker. You, as a jury, are tasked with deciding what was in his mind at the moment that happened. But there is only one logical conclusion, and I promise you, it doesn't have the first thing to do with the phantom burglar who turned into the cold-blooded killer for no appreciable reason. One person was angry at Kay Baker that night. One person was arguing with Kay Baker that night. One person was alone with Kay Baker in that house that night. And one person has Kay Baker's blood on his hands, both literally and figuratively. That man.
Great. I love that line.
He killed Kay Baker. He killed her with premeditation. He plunged a knife into her over and over again. And when she was in a moment of weakness, on the ground, he opened her neck. Not by accident, but on purpose, with one intent. That is who Matthew Terry is. That is who Matthew Terry was on that evening. Do not believe in the phantom burglar. Find the defendant guilty as charged. It is the only just verdict. Thank you.
Well, I like them apples.
Boy, perfect. Excellent. There was one little objection there I could have done on a burden ship, but it would be a loser probably. But that was very fair, very hard. You can, there's a statement that says the prosecutor can strike hard blows, but not foul blows.
Mm-hmm.
And here, these are very hard blows. But I don't think anything he said was outside of argument. Another thing that he did that is correct, and again, we are seeing masterclass on these attorneys and this courtroom here, is that he is legitimately rebutting what was said in the defense. That's why I don't like the defense positing this theory and putting it out there. Let me tell you what really happened. I don't like that, okay, because it sets up this killer rebuttal. If she had left it open, it would have been much harder. Now, what he's done is a rebuttal is supposed to be a true rebuttal argument, addressing the points that were not addressed in the first opening or the first closing argument that were then brought up by the defense. You get to rebut, right? So what happens a lot of times is that prosecutors hold back some of their best stuff and they cheat by holding back their best stuff. And then they bring it up in the rebuttal closing to prevent the defense from rebutting their rebuttal, right? They want to bring stuff up while the defense can't come up. Now, there's a solution to that, and it's complicated, but the defense could say that's not proper rebuttal argument. I want more time, and a good judge should do it, but it's hard to get that, all right? But this is pure rebuttal. He is shooting down the defense stupid theory of the phantom burglar, right? And he also did it. He did it in a condescending way, but he wasn't necessarily mocking it, as in ridiculing the defense, right? I mean, he did it in a way that said the evidence does not support this. It's inconsistent. It's unreasonable. So he went hard, but he didn't go too far. It would be easy to say, oh, that's stupid. Oh, this defense they're out of line. I mean, he could have gone way overboard, and that's improper argument also. It's very good. Can't argue with it. So I hate to say, I'm praising prosecutors. I want to, go team public defender, right? But
I'm glad you're here to watch that. I thought that's why I wanted you here, because I thought you would like that.
Yes, I am enjoying it. It's really good to see great attorneys working. These are attorneys at the top of their game, as they should be. I mean, this is death penalty stuff. So everybody should be playing by the rules. They should be doing their best. And that's what you're seeing here. I mean, the problem here for the defense is that the facts are just very strong. You've got very strong evidence for guilt, right? And you got to play with what you work with. And that's, you don't control, as a defense attorney, you don't control the evidence, nor does the prosecutor really. I mean, or they shouldn't, right? But so you're given the evidence. It's kind of easier to be a prosecutor because it's all handed to you on a silver platter. The cops have done their job. You've got these experts, you paint a narrative. The job of the prosecutor is to kind of orchestrate the play. So, and if the evidence is there, then of course it sounds strong. Yeah, that guy's great. He's a great arguer. Well, when you got all the evidence, it's easy to argue, right? It's hard when you don't have anything.
Brittany says legal vices. Is that why the state went so hard on the charging paperwork till he knew where they were going with their defense strategy and they drove it home with that rebuttal? See, this is the thing. I mean, aside from the fact that was a brilliant presentation, a brilliant argument, but the fact he put that entire thing together that fast.
Oh, but I live and die for this. This is closing my favorites.
That was some of the best impromptu work you're ever going to see. That was just brilliant.
Well, I don't know. I've done better.
To put that sarcastic narrative together in the time it took him to walk from his chair to the podium is good.
Easy. No, that's just no,
for you. Only for you.
No. I like I said, closings are my favorite thing to do. I love closings, and that's like my favorite part of the trial. And it's a skill that you develop over time. It's like objecting skill, but It's not really that hard because he knows the evidence backwards and forwards. He knows the case. And when he hears this stuff, immediately all that evidence fires off in his head of all the reasons that story is bad. See, that's why you don't put that story in as a defense attorney. I don't like that they did that. I mean, but it's their case and it's their client. So, I'm not sure what they did in the background that said that was the right thing to do. I don't know. Let's see the verdict. I think we'll do.
Let's explain the speedy trial.
That's a lot of talk. Let's do the verdict because I want to hear the verdict. And I'm sorry.
We'll give you the nutshell version. You have a right to have a speedy trial, which means you can't be held in jail for 25 years while you're awaiting trial. Generally, I would say defendants tend to benefit from not having a speedy trial because it gives them more time to collect evidence.
Okay.
But sometimes if it's weak and they don't, he's going to tell me I'm an idiot here, but if you have a weak case and the prosecution doesn't have time to do a lot of testing of evidence, you want to get that trial out there as quickly as possible before the prosecutors can put together a good case. That's what I would say.
Yes.
But I'm not a complete idiot, but
people perceive speedy trial as a way to get away from the crime, right? I'm going to demand speedy trial, and the state's not going to be prepared, and I'm going to catch them, and then I'm going to get out of jail based on speedy trial. That never happens. Okay, I mean, maybe there's a couple cases here and there where that happens in the rare case, right? Generally, that doesn't happen. Generally, what speedy trial rights give you as a defendant is a right to force a trial. So if you're sitting in jail rotting and the docket is all clogged up, then you force speedy trial. So you demand speedy trial so that you force a trial. That's what speedy trial really does, is force the state to put you to trial. It's not a get out of trial. I mean, I could explain, it would take me, I could do a whole hour or so to explain why that's so. But there's so many outs for the state to get out of the speedy trial rule and to get delays. So speedy trial is a tool for the defense to force a trial when they want one. How about that?
That's good.
Okay.
I'll buy that.
It's not I want to say almost nobody gets away with crime because of speedy trial, especially murder case. A state should be able to put their case on when they file their charges. They should be ready to go on day one because they've got all the evidence. They've charged them. They think they can prove the case beyond a reasonable doubt. They're ready to go. The people that need the time are the defense attorneys who are just seeing the evidence who needed to formulate a defense. So that's why you get speedy trial waivers on the defense side. So I'm not sure what the strategy was forcing the speedy trial here. Again, it could be client.
Could be. Well, let's find out how well everything worked out for our man, Matthew
I'm not
Terry.
hopeful for my team, but.
Now, yesterday we had one of our regular chat members here worked with Matthew Terry in Michigan at the time the stabbing of his previous girlfriend occurred.
What's that about?
So he came on the show yesterday and talked a little bit about him. He worked with the defendant when he stabbed his previous girlfriend in Michigan.
Any insights?
He said he was surprisingly like normal. No, not didn't have fits of anger. Didn't seem to be jealous. He did send some more information. I wanted to make sure this was like a legit thing. He sent some receipts to prove that this was the deal. But it seemed like
he's an angry, violent drunk. It's because I'm surprised that it was 5 hours, but he had a 1.0, I think, 5 hours later. So he was
0.7 something
off the charts drunk. So he went and tried to kill himself. And stumbled and passed out probably in the bushes. If I was right, is that possible?
That would seem to be what happened to me, as far as I can figure it out.
I'm surprised they didn't have an alcohol expert talk about if you have a 0.7 5 hours after the incident, how high was your alcohol level actually at that? They could probably extrapolate that somehow.
Shall we watch the verdict?
Yeah, let's go, baby.
Here we go.
Let the record reflect that all the attorneys, including Mr. Terry, are present. I've been informed and you've been called that the jury has reached a verdict. We're going to bring them back in just a moment.
A longer moment if that keeps happening.
Obviously, if the verdict is not guilty or a lesser included, I will thank them and release them. If it's guilty as charged, then we have to go to phase 2. How do you prefer? Do you want me to bring them in, get the verdict, and if it is guilty as charged, I send them out, and then we discuss timing for, is that, okay, I don't have a problem with that. I'll just explain to them, if it is guilty as charged, that I have to discuss something with the attorneys. I'll send them back there, and then we'll discuss timing of phase 2 if it's necessary. Mr. Diaz, any objection to that?
No, Your Honor.
All right, anything from the state before we bring the jury in?
No, Your Honor.
Anything from the defense?
No, Your Honor.
All right, let's get the jury.
And apparently, these are all of the victims' friends back there.
The judge is just being eminently fair too. Now, how that transmits, I always question these trials. Like, is this the way they treat every case, or is this just being on their best behavior?
Alan says, Jeff, can you have Steve on your stream with you more? Well, that just assumes there's something Steve is interested in, and he has time.
Well, I want you to double my pay.
All right, I can do that. No problem.
Yeah, zero times 2. No, I really thank you. It's fun streaming with you, and it's usually I like to come on streams where I have something to add. You know, and this is a Florida case. It's a death penalty case. It's murder. It's right up my alley. So, and I'm also taking a lot of vacation days. I've been on a lot of stuff because I've been on vacation a lot. I'm going to go back to my real job soon, and probably won't be as active on media on these YouTube things. I'll try, but it's tough because, you know, I'll take vacation when I'm going to lose it in December. Right. But if I don't take my vacation, I'm waived and lose it. You know, I don't want to lose my vacation. So this is my vacation time.
Yes, I was just mentioning all the young people are her friends. But I don't know. I mean, although all the people back there, but I'm not sure who yesterday, the first part, I don't know who all the young people were. Probably students. Like I said, she was a math teacher. I don't know. But currently those are her friends and things back there.
I saw the prosecutor talk to him. He's just explaining what's going to happen. He's probably saying, no outbursts, things like that.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good evening, I think, is appropriate at this time, but welcome back. I
love this judge.
Deputies have advised, well, first, my question to you is, were you able to select a foreperson? Who is the foreperson? All right, so that is Mr. Williams, correct? So my next question then is to you as the foreperson, Mr. Williams. Was this jury able to reach a unanimous verdict in this case?
Yes, Your Honor.
And do you have the verdict form?
Yes, Your Honor.
If you would please present that to the bailiff. Thank you. Bailiff will present it to me. I will review it, and then I will give it to the clerk to be published. Thank you. Today is the 15th, right? All right. I'm going to ask Mr. Terry, with your attorneys, to please stand for publishing of the verdict, and I will present the verdict to the clerk to be published.
State of Florida versus Matthew Robinson Terry. We, the jury, find as follows as to count 1. A, the defendant is guilty of first-degree murder as charged, and with further findings, during the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use a weapon. So say we all, dated this 15th day of November, 2022, foreperson W.W.
Thank you.
That's it.
Easy. Yep.
That whole thing built up right to that moment.
Wow.
Now we can talk about what happens next. Now it's got to go into the penalty phase, which is phase 2, which is going on right now live.
Is it? They went right into it, huh? Yeah.
Yeah, they went right in the next day. They're going to try to be done with everything by Friday, Monday morning at the latest.
Okay, but that's not the end either. Okay, because what happens is it goes to the jury for a determination of whether or not it's a much different. This is death, and it's very different. And you get every individual juror has to vote for death. It's not a unanimous verdict like it is in guilt phase. It's on the conscience of every individual. So, and you don't have to be rational. All you have to do is you have to be able to vote for life or death. And if you vote for death, that's a decision that you live with for the rest of your life. So it's easy just to say, give the guy the death penalty. I don't really think this is a death penalty. I think it's overcharged, but it may have been, see, the state's already won because they've got him life or death. That's the only possible, the only sentences are life or death. So it may have been that he's just not willing to plea. Like if I'm suspecting what I think, that he's forcing speedy trial, he's not conceding any guilt, he's doing all that, he's not going to plea. The state may have offered him, I don't know, but the state may have offered him plea and you get life. And he doesn't do it. So it's used as death penalty is used as a weapon against him to get him to plea. Now they've got him in the chance. It's a different case. Now, don't think that because the state won in this, I think that the defense is going to switch attorneys and they'll have a good chance at a life sentence in this case. If I was just to spitball it, I know what their training is. And the defense is very well trained on ameliorating death aggravators. So we'll see how it goes. I don't know if I'm down for the penalty phase, but it's after the penalty. Let's assume the jury comes back death. Then there's another month where they do something called Spencer hearings, which is stuff that the jury didn't necessarily hear, but that the judge can hear, because even if the jury comes back death, the judge can then say life. So it's a complicated process, but anyways. Well, you should play the Johnny Dangerously clip.
Yeah, we'll do that on the way out. That's going to be the we're out of here thing.
Okay.
So what they've said is they're guessing. I think he said 9 witnesses for the prosecution. So he's doing it today, and he expects to either turn it over to the defense late tomorrow or early Friday. And they expect the judge said we might run long because he wants it to be with the jury again by Friday afternoon.
Yeah. So if anybody missed it, the jury came back guilty. So now we go on to penalty phase, which is determined. The jury now has to find death beyond a reasonable doubt on everybody. So
that was the jury. What the court just read, that was the verdict. Guilty, for murder in first degree, done.
But in a death case, there is a second trial where the every juror has to individually impose death beyond a reasonable doubt. So they have to find not only the aggravators outweigh the mitigators, which they're going to hear in this penalty phase, but that they vote death beyond a reasonable doubt. Even if there's all sorts of aggravators and there's no mitigators, a juror can still individually say, I want life, not death, based on mercy. So you have to have every juror. It's a very individualized decision, which makes it very difficult because it's easy for somebody in a chat to say, hang him high. But when your vote sends that guy to death chamber, the rest of your life, you will have to live with that decision. And it's a hard decision. It's not an easy, if you ever watch the movie Unforgiven, he says it's a hell of a land. It's a hell of a thing taking a man's life. Take away all he had, all he is and all he ever will be. And I love that movie because it's easy to talk. Oh, shoot him up, shoot, bang, 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 But I love that movie because it's all about the consequences of violence.
Is Florida, by and large, a pro-death penalty place?
Yes, very much.
Okay,
so 80% of our jurors are not qualified to serve on a death jury because they're basically hang 'em high. I would vote for death in all cases. And, it's a very complex thing seating a death penalty jury.
Okay. Yeah. Cause in Utah, it'd be like, can we do it now? Do we have to wait for the rest of the trial?
Yeah. It's, I know I'm in the minority. I understand that. And I used to be kind of 50-50 death penalty. I hadn't thought about it a lot. And the more I researched it, the more I looked at it, I'm just against it. And, I'm working on an article. It's a long-term project on an article about the arguments for and against the death penalty. And it's going to be it's a very complicated thing. It's easy just to fly off the handle because it appeals to rage and vengeance. And that's our initial reaction whenever we're dealing with these horrific fact patterns which are involved. But, stepping away and being calculating about it and being dispassionate and looking at it from the side, do you want the state the power to kill its citizens? There's a lot of issues involved in it, and I take it very seriously. It's probably one of the issues I have evolved the most on as a political matter. I'd say I used to be kind of 50-50, and now I'm basically 100% against. But it's and that's a bit of quite an evolution. And it's in the last 10 years, and usually you don't. But it's because now I'm involved in it. I'm seeing all the different sides of it, and I'm like, oh, this is terrible that we have this. But
I don't know if I'm 50-50 or 100% both ways. I personally believe the death penalty is a necessary evil, but I believe it's applied terribly inaccurately, terribly unfairly, and terribly improperly. So I think it should probably be used more, actually, but the way it's being applied, I think, is the problematic part. So that's I don't know if that makes me like crazy both ways or kind of a 50-50 thing, but
it's part of it too. Like, we all have our opinions, right? But the statute in Florida is flawed.
Mm-hmm.
And there's, so I have questions about the technical aspects of the statute. And then you have public policy objections. Is it effective? Does it interfere with our international relations, which it sure does, which is a negative. Now, how much weight you give to that, I don't know. Does the benefit of having the death penalty outweigh the impact it has on our foreign relations with countries like Mexico and most of Europe? I don't know. But you have to weigh those things, right? There's a moral aspect. There's a religious component. I'm Catholic, and the Catholic Church is against the death penalty. They came out with a revised in the catechism that talks about this, that it's not justified as a religious matter. But if you say, well, I'm not religious, so okay. But there's still moral issues. There's public policy issues. There's foreign relations issues. There's deterrence, whether it actually deters. There's cost issues. It's about 4 times as much to cost. There's a competency issue. There, whether, because the level of attorney that needs to do this, like these attorneys you're seeing are the best at what they do. But that's hard to find those kind of attorneys. It's hard to find them in the public defender's office, hard to find them for the prosecutor's office. So, and then you've got possibility of innocence. Florida's number 2, I think 1 or 2 in the country for exonerations, death penalty exonerations. So you got the possibility of innocence. There's just so many aspects to this that are complex. So, it's not an easy thing. If you think it's an easy call, you haven't looked at it. Look at it some more, please.
I don't think he's going to get the death penalty in this case.
If I'm going to say, I think you got at least a 50% chance he's going to get life. If I was to put money on it, I don't think this is a death penalty case. See, part of the problem with the death penalty in Florida is that everybody qualifies. Everybody who's got everybody who's got a first-degree murder charge qualifies. That is not in this. The U.S. Supreme Court says that you cannot have every case that's a first-degree murder qualified. There must be a winnowing. It has to be reserved for the worst of the worst. Okay, and the statutes are such that you have to have one aggravator. And for example, the heinous, atrocious, and cruel, hack, what we call hack aggravator, applies to every first-degree murder. So, and if you only need one and it applies to every one, then there's no winnowing. So that's one of the attacks. So people say, well, what do you do on appeal? Well, number one is I say it's overbroad, that it applies to everybody, and that is not consistent with the U.S. Supreme Court's view of what the death penalty should be. In this case, one of the questions I had, and I sent you a bunch of stuff on this in the chat, is that there is also an aggravator called CCP, which is cold, calculating, and premeditated. That's different than the mens rea it requires to get this guilty verdict. It has to be pre-planned. Now, if they're going for CCP in this, it's an error. So, what they're doing is you've got, was this cold? Did he contemplate what he was going to do? See, I don't think there's any evidence to that. He was doing this as a fit of rage, is a thing. So if the state goes for CCP, and they may get it, is that error? Does that create error in the death penalty? Because the jury found as an aggravator this aggravator, but as a matter of law, it shouldn't be in there. See, so this is the kind of thing that was one of the. I had a death case which I did the appeal on, and this was the very issue: is the guy was acting in a heat of passion, and the jury found beyond a reasonable doubt that CCP was there. But under the case law, it has to be cold, calculating contemplation. I think I sent you a case on that in private chat, which is on CCP. Oh, yeah. Here, I'll read it to you from Williams v. State, Florida Supreme Court, 2010. CCP, cold, calculating, premeditated, involves a much higher degree of premeditation than is required to prove first-degree murder. So, and there's cases where somebody goes off and for an hour, leaves the scene for an hour and comes back with a gun and shoots, and that was insufficient for cold, calculating, premeditated because he was still operating in a heat of passion. And that's what you have here. So if the state goes for CCP, it's error. Now, we have a pro-death penalty Supreme Court in Florida, but then we've got federal courts, and it's not sufficient under the U.S. Supreme Court, in my opinion. So then you're going to have a U.S. and then it could get kicked back for new penalty phase because they've got an aggravator in there that is overbroad. So this is the kind of thing that what death penalty brings forward to the lawyers. I'm just talking.
No, and I think they're gonna make a good case for it because they mentioned that they're going to be bringing people from Michigan to testify for the defense. Okay. So they're going to bring people that are going to say, "Hey, he's even keeled. He's never done this before. He has no history of this except for once."
Yeah, he's a violent drunk, and he was way overboard. You know, this is the thing. See, as a defense attorney, you sit with him and you get a relationship and you see the human side. See, the prosecutor side just sees the person as defined by the crime. And that's fair enough. I mean, I'm just saying it's different perspectives. Whereas a defense attorney, you're sitting with him, person's got a lot of human traits. You know, they've got kids. They're not all evil. So this is the balance. The defense's job is to humanize him. The state's job, or what the state's trying to do is saying, this is unforgivable. This is the guy's going to do life in prison. I mean, he's life in prison without possibility of parole. So does that make me a softie that I think that's sufficient for murder? Am I a bleeding heart? I mean, I think it's sufficient. I mean, you know, the fact is like in Wisconsin, this Darrell Brooks case, which is just terrible. The fact is that the victims are coming forward and they're thankful for the state and they're saying justice was done. We got our maximum sentence. You know, if this guy doesn't get death, are the victim and the family, are they going to be disappointed and feel like they've been betrayed by their system? You see, I mean, it's kind of like death does not resolve anything. My biggest problem with the death penalty is that it's a lie. Mm-hmm. Because the prosecutor turns to the victims and the victim's family and says, if we get death, that is justice. Well, that does not, if you say, and if we get life, it's injustice. See, that it's a lie. Yeah. You get the death penalty on this guy. The victims aren't going to say, oh, great, that was wonderful. Now we feel better. No, they're still faced with the same tragedy. They're confronted with the same emotions. There is no satisfaction in the death penalty. And it appeals to that vengeance, but vengeance satisfied does not resolve the issues that the victims here are dealing with, the victim's family, right? They're still left with all the issues in their heart of hatred and anger and loss, and it's not gone away by the magic wand of the death penalty. So for the prosecutor to tell that to them is a lie. You see? So that's a big problem I have, and I don't believe in lying. You know, it's a sin, and you shouldn't do it. So I don't know. Maybe it's just me.
And a lot of people in the chat are asking, how long did the jury deliberate? Just about an hour.
Okay.
And that was to.
It's a pretty clean case. It's a clean case.
That was to go in, appoint the foreperson, read the instructions, and fill out the form and give it back to the judge. That's about how long that took. But so what we're gonna do here on the channel is, starting tomorrow, we're gonna push O.J. Simpson back a week. We're gonna skip O.J. Simpson Day tomorrow. We're gonna watch the penalty phase at 1.25 speed. I really do have to sleep at some point in my life. I'm only human. I can't work 9 to 6, come home, do all the stuff, get on here at 10, stream till 7 o'clock in the morning, get dressed and go to work by 9 every day. So we're gonna break it up. We'll do morning session one day, afternoon session the next day, morning session, the afternoon session until we're done. So probably be like Monday or Tuesday of next week when we'll wrap it up. So that's what we're gonna do. We'll do it. I got nothing else to do. Nothing else on the law horizon. So if you're welcome to join anytime you feel free to do. Don't feel obligated to join, Steve. But
I'm not sure if I'm down for the penalty phase, but
Yeah.
it's so. I mean, I limit my connection to the pain. I'm a very emotional, sensitive guy, and the death penalty is yucky, and so is murder.
Yeah. And but we're gonna go out here on a bit of a clip here. But before we do that, thank you so much to everybody that participated this evening. Thank you, mods, for keeping us under control as always. You're the best mods in the business. Chat, thank you for being here. You're the best chat that anybody could ever ask for on the internet.
You have a very nice chat, and they also came forward and they bought a number of my books, and I thank them for that because your chat is quite respectful. Some chats aren't quite as some chats are nuts.
Yeah, they know where the line is without having to be told. So they're teach them correct principles and let them govern themselves. That's how I look at it. And everybody that super chatted, thank you guys. Speaking of super chats, we've got a couple just came in here. Ben Samuel, thank you so much. A life sentence is death by bureaucracy.
Yes.
And our very last super chat. No, it isn't actually. Pinochet's helicopter tours. The death penalty is a sort of Damocles deterrent.
Well, look at the name of the chatter there. Pinochet's helicopter tours. Where on the political spectrum are you?
And Eva Torres, you are both the good cop and good cop of LawTube. Wait till they get to know us a little better.
Yeah, that's right.
But thanks to all you super chatters. You guys throwing your hard-earned money at me for a reason that I will never, ever understand, but I deeply appreciate it. Make sure you go to crimelaw.net. Check out Steve. Buy his book. You won't regret it. And subscribe to me. And come back for more. Want to set this clip up while I pull it up here?
Well, this is, you're talking about what does a defense attorney have to do to get into the mind frame to go and deliver a closing argument like that? Because you've got to buy it. You got to believe in what you're saying. I mean, reasonable doubt is always there. Do you believe this mountain of evidence beyond a reasonable doubt? Well, I don't know. Let's see. What's Danny DeVito have to say about it?
And this is Johnny Dangerous here.
Great
Dangerous Lee. Yeah. So this is 1984. Johnny Dangerously. Okay. Start at 30 seconds. You say
about 28. Back it up to some.
All right.
We'll that's good right there.
Yeah. All right. Yeah. Got to come into the room first. And there we go. Make sure the volume is up. Yeah, we're at 600%.
Good news, sir. I've got enough evidence here to put Johnny Dangerously where he belongs.
Holy Kelly, we don't even know such a man exists.
Until now. Sir, I have got conclusive evidence. Notarized depositions. Tire prints. Blood samples. I've got eyewitness accounts. Murder weapons. Fingerprints. Recording.
Hold it, kid. It's flimsy. It's not enough. It'll never hold up, not in the court of law. Let's put this aside. We're here to socialize.
I love that clip. That's what I always think about whenever I'm getting ready. I'm like, it's not enough. It wouldn't hold up in a court of law. And I love that. It's so wonderful. So,
shelf paper.
Johnny Dangerously is so funny.
All right, guys. Thank you all for being here. As always, Steve, thank you. You're welcome anytime, regardless of what we're talking about.
Well, thank you. That I only come on when I have something to add. And this was a great trial to cover because you get to see some great attorneys, great judge, interesting case, and have fun with it going forward. All right.
And great guest lawyers on my channel too.
Oh, thanks.
And everybody take care. Enjoy your legal vices. We're out.